One to
Wait. Yes. When dismissed for default? Non-prosecution. Is it appearing in the list? Have you served notice upon other side? Then serve notice Thursday to be mentioned. Yes. But serve notice upon other side. Without notice, I will not entertain. Yes. Ex-employees? Motion or hearing? Hearing, wait for some time. Today the combined list has been published. So you wait for some time. I will consider it. Yes. When dismissed for default? Within time. Yes. File hand over the slip. Monthly list of the January 2026 under the heading application. Yes.
I have mentioned your lordship directed to appear in the monthly list of December, not appear your lordship take up.
So files are not available.
Yes, that is
so you take steps so that the file can be brought in. My officer has how many? Motion of which year?
Motion. 2024.
22 motion.
Yes, that is motion. Report was directed to file a report.
Very well. About requisition party, they will send the requisition party. Yes.
Playing liberty to mention.
You have to wait. Yes.
Playing liberty to mention one matter, and is service before the government. And
what do you want?
In motion.
Motion of
yes.
which year?
2021.
21 motion. How it is possible?
Yes. They haven't.
What was the last order passed? Tell me what was the last order passed. Show me that order.
I have no.
Very well, mention on next Monday. Yes.
2013 contempt application.
Contempt arising out of the order passed by this court or other court?
Not by
this court.
Not by this court, by other honorable judges.
When the order was passed?
Order was passed long back, Lordship.
Contempt application of which year?
2013, Lordship.
13 amount determination আছে কত থেকে বেশ 12 থেকে 18 নিয়ে নাও next monthly list. Yes.
Milord, to be mentioned matter, Milord, in place of group 6 plus group 9 has been written in the form application, Milord. That is the only, Milord.
Whether the matter is appearing in the list?
Milord, no, they are not, Milord.
So what can be done? Matter is there. It's a group 6 matter.
No, Milord, I have released already.
From is it you got the matter released from other court?
Yes, Milord.
And now you are mentioning it's a motion?
Yes, Milord.
Motion of which year?
2024, Milord.
2024. Monthly list of January. Yes.
Milord, to be mentioned, Milord. Only group 6 will be written in place of group 9.
That is not required at a time of hearing that this correction can be made.
Okay, Milord.
For that matter need not be placed under the heading to be mentioned.
Deeply obliged.
Yes.
Deeply.
Mention a new motion for urgency. May indicate the urgency. This matter pertains to group 6, but it was filed in group 9. Last Friday, it was heard by Mr. Shubhra Ghosh, and her ladyship has passed the order saying that this matter lacks a determination of her ladyship, so the matter is released, But the matter is that, the petitioner.
What is the urgency?
The petitioner is a village police. Now,
village police.
Now, my lord.
What is village police?
Village police, a post, arising out of a 2012 notification issued by the government of West Bengal. Now, my lord, from 2012, he has been rendering his service. Now, all of a sudden, 15th of October, in or around 15th of October of this year, he has been told not to come, not to report duty, verbally, without assigning any reason, without any order, my lord. Now, my lord, there is a political nexus, my lord. His father is a leader, my lord, with allegiance to the opposition party in the state of West Bengal. Now, my lord, prior to his verbal communication, his father was asked by the ruling party to switch over, my lord. His father declined. Thereafter, my lord, this action has been happened.
So his service has been discontinued from 15th of October. We are on 1st of December 2025.
My lord, we have made representations, my lord. That was not, my lord, answered to. Thereafter, we filed the requisition on, my lord, 15th of November, my lord. 15th or 14th of November, my lord. Then the matter appeared before our ladyship, my lord, upon mentioning, indicating the urgency as a petitioner is, my lord, is a hand-to-mouth situation, my lord. Now, my
Very well, 15th of December motion, supplementary list, yes.
may I indicate one 15th of December, I have some personal, my marriage is scheduled. And any day, prior to that, kindly, I have.
From which date you are not coming? You will not be coming.
From 12th. Right.
11th December.
Having
Item number 348. Monthly list, Lordship, may I mention for upgradation, the emergency.
What is the urgency?
Yes, Lordship, the urgency is that the petitioner was rejected, was not qualified in the post of constable because of his height. Now, the recruitment process for this year will be over in December. Then I have attached.
Writ petition of which year?
2025.
When you have filed it?
I have immediately after I got the,
When you have filed it, on which date?
in July.
Then
Thereafter, Lordship, it was filed before.
it is appearing in the monthly list.
Yes.
Item number
48.
248. So,
Notification of.
so what is the present stage of the selection process?
The medical will be over on 12th of December.
So if medical is over, then already one part written test is over.
Yes, yes.
So then how we?
But he got disqualified because of his height. Whereas last year, he was qualified for his height. So this is the irony.
15 December. Yes. Restoration application I always allow. Why you are mentioning? File is not available. File has to be brought in. The requisition has been sent. You take steps. Yes. Hearing or motion? Wait. Yes. Sorry, wait for some time. I have refused others. All files which are available in court have been included in the list. You hand over the slip, try to bring the file. Also, my court officer will send the file. এই দেখো তো ফাইলটা কেন আসছে না? Yes. Contempt arising out of the order. I have passed order. Old contempt. On which 14th November 2025. It's not an old contempt, new contempt. Contempt arising out of the order passed by this court. কি বলছে কিছু বুঝতেই পারছি না। 17 order was passed. Huh? Passed by which court? Order passed by which court? You are not aware, Mr. Rai? Ascertain and then mention. Sorry. Yes. In 2017, this court was not available. Yes. Yes. Next matter. Yes. Mr. Dotto. Yes. File is not there. এই দেখো করলে দিয়ে দেবে, it will be included in the list. Find it out whether the files are there. This was heard when? Yes, when it was heard? September. And there was a direction that the matter to appear on November. দেখো তো ফাইলটা দেখো। Of which year? 2025 motion. When the last order was passed, what was the order passed? Writ petition of which year? 2025. See, hearing matter, you have to wait for some time. Yes. Hand over the slip, monthly list of this January. Yes. The hearing matter, you have to wait for some time. I am not including hearing matter at present. Hand over the slip, but it will not be included now. Let me see when I will start including hearing matter. Your matter will be included. You have to mention at that point of time. Yes.
Yes. To mention some hearing.
Wait for some time. Wait for. Let me see how far I can reach. Then I will. Already there are certain hearing matters in the list. Yes. Yes.
Application for restoration
When dismissed for default?
in the month of August.
By which court?
Honorable Justice Anindam Mukherjee.
Hand over the slip. Monthly list of January. Yes. 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 Yes.
May I have your lordship leave to mention one matter for inclusion contempt matter passed by your lordship on 5th March 2025.
Contempt arising out of the order passed by this court.
Yes, your lordship.
Hand over the slip. Monthly list of January.
Some precedents may
My
be
lord.
given to these matters. Some earlier date be given because your lordship has directed the board to conclude the proceeding against the petitioner at an early date.
Very well. Hand over the slip. Contempt. It will appear in the
My
monthly.
lord,
list.
this is an inclusion of a CAN application. The main writ petition was fixed on 17th of this month, November,
Before this court.
before Justice Ananda Bhattacharya.
Yes.
Then, my lord, in the meantime, writ petition is died. CAN application is filed. CAN application before that.
Application monthly list of January under the
But-
heading application. Yes.
Sir, final hearing is fixed.
No, at this
petition
stage
in the
I am not
meantime-
including any hearing matter. If you want the substitution due to death of the petitioner, substitution application can be taken.
My lord,
Yes.
this month,
No.
It's
Yes.
an assigned matter, Milord. The second week of November, I mentioned this matter, Milord, that I have taken out an application so that the selection process can be conducted. There is a stay of this.
Yes.
Milord, you will ask me, Milord,
But application is appearing along with the
Yes, yes.
main matter. This is item number.
379 and 381. Any day as per your lordship's convenience, finally, Milord.
379 and 381.
Oh.
What is a contempt heading?
No,
379.
Milord, of the monthly list.
Yes, monthly list. I am on the month. Just a minute. No, no, no.
This must be under heading assigned matter. Assigned.
Matter relates to
Milord, subject matter is Milord, this, there is a corruption in the Milord, recruitment of food SI, sub-inspector of food, Milord. Now, Milord, that was challenged. Now, the stay was granted by this court and the investigation was directed to be done. Now, Milord, investigation has been done in a farcical manner. There is one of them, Milord, contention.
you have mentioned the matter on number of occasions. Another lady has mentioned, advocate has mentioned this matter.
Yes, Milord, I mentioned, Milord, in
Yes.
the month second. Do the month,
When I
ask me
take,
to,
I will
Milord,
indicate. I will indicate when the assigned matters will be taken.
Milord, ask me to, Milord, remind you, Lordship, after fortnight.
Yes, yes.
That's
It is already in my mind.
Milord, in the meantime, only difficulty is we are crossing our age, Milord. We will not be able to, Milord, participate in any selection if it is held, Milord, in future.
It says 2024, basically hearing matter. Let me see. Let me see.
And any day in the next or after.
No, now I cannot give you what, but you have to go on watching the list. Let
May
me
I
see.
come back in the next week?
You can come back. Nobody can prevent you. So you're right. Yes.
Mentioning with regard to rounding of height in the CAPF matters, my lord. The medical will be over by 12 this month, my lord, if this can be upgraded, my lord.
This is happening at serial number 205 and 207. When you have filed it.
Well, it's 2024 matter, my lord,
So what you are doing for such a long time?
to break the matter.
No, not at this stage. No, sir.
My lord, there
2024 matter. Sorry, no urgency. Yes. Please call the please next. Please don't disturb this court. Yes. Sorry. Maybe. Sorry. Yes. Next matter. Yes.
For inclusion in the list, lordship. New motion of 2024.
New motion 2024. Yes. Monthly list of December, January.
Matter was directed to appear in month of November. The matter was not appearing. He had mentioned before your lordship rejected the matter to appear.
Files are not there. What can be done? Yes, yes. Monthly list of January. দেখো ফাইলটা আনাতে পারো কিনা হ্যাঁ yes restoration dismissed by which court? Yes, matter relates to which group? Matter relates to which group? Hand over the slip, monthly list of January. Yes. Hand over the slip, monthly list of January.
Last month, however, my lord was the opinion that Ramesh whitewash was not
This court is not inclined to enter into the merit of the case. What do you want? Tell me regarding listing, whether it is appearing in the list. Motion of which year? Hand over the slip, monthly list of January. Yes. Is not in the list. Hand over the slip. Yes. Hearing I am not including now. Yes. Sorry, madam. Yes. New motion. 2025 motion. Upgradation. It is already appearing in the list. What is the urgency? Hand over the slip. It is already in the list. No upgradation, sorry. Yes. Files are not available. What can be done?
There was a direction that those who lost their job previously will not back to their jobs. Well, I am one of such candidates. The employment will 31st of December.
You are in you have grievance against SSC. Then
my grievance is against the Punjab National Bank, my lord, because they are not taking us back, my lord. Although
motion.
Yes, my lord.
Hand over the slip, monthly list of January. Yes.
31st December, I have been employed.
What can be done? What can be done? Yes. I have allowed your mentioning. If files are not there, what can be done? What for you are mentioning? Is it in the list or not? Motion of which year? 17 motion can't be. Hearing matter, I am not including any. Sorry. Then I have to allow others. Yes. Let me see. No. Don't hand over. Motion or hearing? Motion. Hand over the slip, monthly list of January. Yes. Motion or hearing? Hearing you have to wait. When there will be an indication that hearing matters will be allowed, then you mention me. Yes.
My lord, may I be granted your lordship's kind leave to mention a matter for upgradation, lordship. Lordship, the urgency, it is appearing as item number 249. Lordship, the urgency is that I have retired in the year 2024. Until date, my pensionary benefits have not been disbursed. Lordship, being a senior citizen, I'm solely dependent on those retirement
Wait for some
benefits.
time, let me see. If I take up the hearing matter, motion relating to pension, then I will consider you.
Grateful, my lord.
Because it said service determination, there are other pension matters. Then I have to take all the pension matters. You have to wait for some time. Yes.
One matter, this is our motion stage, my lord. 2025 is the year, my lord.
What do you want?
My lord, for inclusion, my lord. My lord, the returnable.
Motion, it is not appearing in the list.
My lord.
Our writ petition of which year?
2025, my lord.
Hand over the slip, 2026 January. Yes.
May I permit to mention one matter for restoration? It's a
When dismissed for default?
Dismissed for in September by Justice Rajti Bharat. Group 6 matter.
Group 6, Justice Bharadwaj didn't have determination at that point of time.
My lord, it's a contempt matter. Old contempt of 2012.
Contempt application dismissed for default. Go before Justice Bharadwaj. Justice Bharadwaj is available. Don't mention this before this court.
It is not an order of Justice Bharadwaj, but it was appearing in the.
Who has dismissed it?
Justice Bharadwaj on last dismissed for.
But he didn't have determination of Group 6 at that point of time. Yes, please ascertain. Don't waste court's time. Sorry, yes.
I mentioned this 2022 hearing matter in November also. Your lordship directed the matter to appear in the monthly list of December. The matter is not appearing. The main urgency.
Files are not there. I have directed my officer to include all matters where I have allowed mentioning. If files are not there, what can be done?
Only one sentence. That is, this petitioner is retiring right after this month only. The matter is relating to his career progression scheme promotional benefit, and his pension may get affected if he doesn't get.
Hand over the slip. Let it appear in the list.
Then, my lord, I am trying before the other hearing bench. Please.
Yes, yes. It's a hearing matter. Try before the other court.
Lordship, if I may be permitted to mention, your lordship. Lordship, this matter pertains to compassionate appointment, your lordship. Lordship, on 11th August 2022, your lordship had passed an order directing that the matter be taken out of the list because
11th August 2022.
Yes, your lordship.
This court passed order.
Yes, your lordship.
So yeah, it's a contempt petition.
No, your lordship. On the ground that the matter was pending before the Supreme Court, your lordship. On that basis, lordship had directed, lordship had given us liberty to mention.
Matter relates to which group?
Lordship, Group 6 compassionate appointment, your lordship.
Compassionate appointment relating to which, what service? Father was working where?
Lordship, my father was deceased, was working in SBI, your lordship.
Oh, yes, yes. So now what do you want?
Lordship, the lordship directed that let the matter be decided by the Honorable Supreme Court. Thereafter, lordship granted us liberty to mention.
Yes.
So the matter was decided on 14th of May 2025, your lordship.
What was the decision taken by the Honorable Supreme Court?
Lordship, it was acknowledged and the Honorable Supreme Court had directed that the compassionate appointment be given. On
yes, yes. So till date it has not been given.
Lordship, on that basis I am mentioning, your lordship.
No, if Supreme Court has decided this matter, then already the petitioner is entitled to be appointed.
Yes,
and
sir.
if there is no appointment, then you move the Honorable Supreme Court in contempt.
Lordship, but this matter was still held pending before your lordship.
Yes.
This matter was still held pending before your lordship. This was not.
No. What for you are mentioning? Since it is decided by the Honorable Supreme Court, then matter ends. What further decision this court will take?
Lordship,
that I fail to understand.
Lordship, only to acknowledge and pass an order that on self-same cause.
Show me the order of the Honorable Supreme Court.
Lordship, I have it.
Bring the order. Let me see. Yes. On next Monday. Yes.
Motion matter 2024, my lord. It is a pension matter. He is not getting pension till 21, my lord. It is distress condition, my lord. Kindly let
pension matters, you have to wait. I am not including any matters. Hearing matters. First, I have to give preference to motions. So wait for some time. Yes.
Matter 24, my lord.
Yes, yes. I have not allowed any inclusion of hearing matters today. Yes.
New motion for inclusion, lordship.
New motion for inclusion. New motion of which year?
25, lordship.
Yes, hand over the slip.
24th of last month, I mentioned before your lordship for inclusion. New motion matters. The lordship had allowed, but it is not.
Find out from my officer whether files are available in court or not. You can submit, but if records are available, then it will be included. So find it out whether these records are available in court or not. देखो तो records दे. 20. New motion handover next month list. No. Unless until I am satisfied on urgency, I am not fixing any date. Yes. Both are new motions. Hand over the slip. January 2026. Yes. So it is not appearing in the list. So files records might be not available in court. So দেখো তো রেকর্ডসটা আছে কিনা, অনেকেই মেনশন করছে কি ব্যাপার হলো রেকর্ডস। All records which are available, those are included in the list. Again, send requisition. Try to get the record from the department. Yes. Whether the writ petition is at the motion stage or hearing. New motion of which year? Hand over the slip, monthly list of this, January. Yes.
Mentioning this for the second time, my lord, because there is a hearing matter. But my lord just please to allow it on the last month list to appear, directed to appear this today. That the files could not be traced. I have inquired.
I directed the hearing to be included.
In the monthly list of December, my lord, because there was some urgency in this matter, my lord.
Very only files are available, it will be included.
Files are available. No, at that point, files could not be traced. That's the difficulty.
If files are not traced out, then
I have traced out the file. The file was lying in another court, my lord. To trace out the file.
Send the file. Let me see.
My junior brother also mentioned, my lord, on a quantum matter. This quantum relates to, my lord, Judge Miller, who has already retired. In the year 2020, the order was written to 2012. My lord, thereafter, it was taken up by my lord Justice Rajashri Bharadwaj, and my lord, thereafter dismissed for default. The file was not traceable. File suddenly came up in the list, and thereafter dismissed for default. My lord is having that determination right now.
Dismiss for default.
Yes, but this is for default restoration application.
Group 6 matter.
It was earlier Group 6 matter. On the order of the Group 6 matter, my lord, it was a contempt. The content was, my lord, this is for default. With the Group 6 matter, my lord.
Monthly list of January. Yes. Yes.
My lord, I am mentioning a matter. This matter was previously mentioned in the month of November, and my lord was pleased to direct that the matter will appear in the month list of December. But my lord, however, the matter is not appearing in the month list of December, my lord. My lord, is urgency, my lord?
First, let the record be forwarded to this court.
My lord, just 1 minute, my lord, this petitioner is the sole earning member, and my lord, he is denied with salary, my lord, more than 8 months, my lord. If
Let the
matter
record be sent to this court. You also make an attempt. My officer will also try.
kindly
Yes, please. Next matter.
Maybe permit to mention one
Hand over the slip. Yes.
restoration application.
Dekho to record. Yes.
Restoration application, my lord. Order dismissed for default, my lord. On May 2024, my lord. By honorable
Group 6 matter.
My lord.
Group 6. Hand over the slip.
My lord,
January monthly list.
inclusion as a new motion. I am praying for inclusion as a new motion.
Hand over the slip. January monthly list.
The urgency is your petition is
When the writ petition was filed?
2025.
In which month? We are in the month of December. When it was filed?
September.
September. What was the date? Yes, what is the urgency?
This is a petition is a home guard. Due to false criminal case, he was demobilized. After
He lost in a criminal case.
No.
Or he was acquitted in a criminal case.
He's a acquittal presently. After that, the representation made to his office, but they are not responding. State authority did not responding. He's a earning member.
So it is appearing in the list.
No.
Hand over the slip. Monthly list of December, January. Yes.
for inclusion on one content matter. It is passed. The order was
Order passed by which court?
order passed by Justice Sirkant Prasad.
Hand over the slip.
Lordship, one new motion for inclusion. Lordship.
Of which year?
2025.
Hand over the slip. December, January. Hand over the slip. January monthly list. Fixing is not possible. Yes.
Upon notice, Lordship, this is a Group 6 hearing matter.
Hearing, I am not including any matter.
Difficulty I am saying is that the regular hearing bench which is sitting is cannot take up this matter because his lordship had appeared on behalf of the bank authorities. I am challenging. This is a matter relating to compassionate appointment. Lordship, his age will be passed. So therefore, Lordship, I cannot mention before the regular hearing bench. Therefore, Lordship,
So you have to wait for some time. I am not including any hearing matter at present.
Lordship, then.
Wait for some time. When hearing matters will be included, you will get chance. Yes.
Yeah, my lord, kindly to mention a writ petition of 2025, my lord. This is possibly at the deemed motion stage because an affidavit direction was given. They have not filed it, my lord. The urgency is that, my lord, this concerns livelihood of employees of this High Court, my lord, who assist your lordship in dispensing justice on a regular basis, my lord. The data entry operators of the High Court Legal Services Authority, my lord. We had filed a representation for consideration of grant of benefits, my lord. That
when the dismissal order was passed,
my lord, the dismissal order was passed. My lord, we had given a representation And pursuant to which, my lord, the impugned order was passed on 14th of August 2025, my lord. We mentioned before the vacation bench, my lord, the vacation bench gave a direction saying file affidavits 3 weeks after.
Mr. Sen, you have already seen that in other matters I have
Which is why, my lord, I bow down.
disallowed. So when there will be an indication, please mention.
My lord, their contract is expiring at the end of this month.
Hearing,
That's my only prayer.
it's a service bench.
Bow down, my lord, whatever falls from your lordship, but that contract.
So therefore, when there will be an indication mentioned, it's a hearing matter. If ultimately you get the job, you will get the job. But at
Well,
this
they are
stage,
already employed. Well, they're employed, but their contract is expiring. At
he has lost the job.
No,
Yes.
my lord, they're in service, my lord. They're not receiving the benefits that they're obligated to receive under law, my lord.
So then there is a better position than what I was thinking.
My lord,
He
their
is working
contract
and he is getting job. But for an interim period, he did not get the salary.
Never, my lord. Since date of joining service, till date, my lord.
Wait, let me see.
May I hand over?
Hand over the slip, but it will.
I bow down. I bow down. I'm very.
May I permitted to one mention? This is contempt application.
Arising out of the order passed by this court.
Yes, my lord.
Yes.
Lordship, may I be permitted to mention, may remember, before 2 weeks, I have come before your lordship praying for a modification of an order which was passed by your lordship pertains to your lordship earlier determination. Lordship asked me to come by filing a proper application. I have filed this application.
Order, you are seeking modification of the order passed by this court.
This pertains to your lordship, pertains to
Who
lordship.
passed this order? I passed this order.
Yes, lordship.
And you are seeking modification.
Yes, lordship.
Very well. Monthly list of January under the heading application serve notice upon other side. Call the list.
Grateful, lordship.
Item number 1 and 2.
My lord, regarding item number 2, my lord, WP number 2185.
Indication দিতে হবে পুরো পরে শোনালে প্রচুর মেনশনই হচ্ছে
আমার কাছে 85 of 2024, my lord.
Just a minute.
Actually, I beg to appear on behalf.
দাদা জজ সাহেব দেখছে তো ওরা। দিয়ে দে সময় হবে এটা দিয়ে দে নামটা সময় হবে
Yes.
My lord, regarding item number 2, my lord,
Yes.
Mr. Rejaul Hossain appearing for the state, my lord, due to the death of his mother, my lord, he left the court, my lord. So kindly adjourn.
Who is appearing item number 2?
2, my lord. So far as
just a minute. 2185 of 2024.
2185.
Yes, I directed that this matter 2184 to appear along with this matter. So who is appearing for the state?
Mr. Rejaul Hossain is appearing for the state, my lord.
Yes.
His mother expired night, my lord. He left he is out of station, my lord. So just a minute, I am submitting. So, my lord, he left out of station, my lord. So I am praying for lordship as per request, my lord. Not this
in terms
week,
of
my
the
lord.
order dated 4th November 2025, both the writ petitions are taken up for consideration when accommodation is prayed for on behalf of state respondents in the writ petition on behalf of the state respondents in connection with the writ petition being WPA 2185 of 2024 on the personal ground of the learned advocate. Next paragraph. However, whether the writ petitioners in WPA 2185 of 2024 are present today?
Yes.
You are representing both the writ
No,
petition
in the
and
first writ petition, Lordship, I appear on.
you are
behalf of-
representing writ petitioners in WPA 2054 of 2025. What about the writ petitioners in WPA 2185 of 2024?
No, I don't know, Lordship.
Then
I
you
do
have to
not-
serve notice. Then you have to serve
2005
notice.
2054, we are for the state.
That I understand. But matters are to be heard in presence of the learned advocate representing the
Certainly,
petitioners in
certainly
285 of
The
2024.
petitioner should be there.
Stop. Acceding to the request made on behalf of the state respondents. Hearing of these matters stand adjourned. Stop. List the matters under the same heading for further consideration on 22nd December 2025.
22nd December.
Yes. Stop.
Deeply
Learned
obliged.
advocate representing the petitioners in WPA 2054 of 2025 is directed to serve notice upon the petitioners in WPA 2185 of 2024 or the learned advocates representing those petitioners, enclosing copy of this order by 7 days from date and file, or by 10 days from date and file affidavit of service on the next day. Stop.
I'm good. Deeply obliged.
Next. Yes.
Item number 3.
Yes.
My lord.
Life of the panel, how long
lord,
it
my lord.
remains alive?
I asked the person concerned, my lord, and he has given me this by WhatsApp, my lord. Arey, এটা life এর জন্য।
Yes, tell me how long the panel remains alive.
My lord, the moment selection process is over, the life of the panel ends.
No, that can't be.
That is what they are saying, my lord.
That can't be. Show me the rule.
That is
What your officer is saying is not correct. It's not sacrosanct. Where is the rule? I want to see the rule.
Absolutely, my lord. The fact is that we are the creature of commands, my lord. Whatever is
No,
given,
no.
we say. We
Then
don't
if
add
you
anything from
are
ourselves, my
unable
lord.
to, then let me take up the matter. I know how to deal with this.
My lord, my lord.
Yes.
Be that.
Where is the rule?
I do not have.
There,
any.
without any rule, your department is initiating selection process.
My lord. No.
My lord.
No, my lord. I am not
Then
on that.
where is that rule
My lord,
which talks about life of the panel?
this is what they have given me, my lord.
Cannot be. Cannot be. Your officer has no right to do this. It's a public employment.
Certainly, my lord.
So then where is the rule?
My lord, the officer concerned is on leave, my lord. And the other one, he supplied me with all these things, my lord.
Where is the rule relating to appointment of Constable GD in Central Armed Police Forces? You are representing Union of India. It is your duty to place before this court relevant rule in order to assist this court.
Certainly about the lifespan of the panel. I stand corrected if I'm wrong, my lord.
Where is the rule relating to lifespan of the panel?
My lord, I asked them, my lord. The person concerned is on leave, my lord. They provide me with these circulars, my lord. Be that as it may, my lord, kindly allow me to place one paragraph, my lord. Thereafter, pass an order. One paragraph of this, my lord.
No, order cannot be passed without seeing the rule.
Certainly, my lord, that can be. But before that, my lord, kindly see this one para order, my lord.
Yes, which document?
My lord, two judgments passed by two different judges of the subordinate court, my lord. Kindly come to page 2, the last para, my lord. Maharaj, that was by Justice Arindam Mukherjee, and thereafter a similar order was passed by Justice Aniruddha Roy, my lord.
December 2024.
Yes, sir. Similar issues, my lord. Para 7.
Supreme Court is time and again saying, suppose a selection process, try to understand.
I understand, my lord.
Suppose a selection process is initiated and where the petitioner has grievance relating to that selection process, as it is happening in the
My
case
lord,
of
my lord, my
the
lord.
School Service Commission matter.
My lord, my lord.
The person is having a grievance relating to selection process, and it is his contention that he has been denied of opportunity to be considered as one of the candidates.
My lord.
Now a panel is prepared.
My lord.
Now, after preparation of panel, if there is no rule, in normal parlance,
For 1 year, my
it is presumed that the life of the panel is for 1 year.
1 year. That is
In certain rules relating to selection, you will find that there is a specific provision relating to life of the
life of the panel.
Now,
Exactly. my lord.
if anybody having any grievance relating to the selection process approaches this court within the lifetime of the panel, then he has a case.
He has a
If even after the selection process and after preparation of panel and before the expiry of the life of the panel,
certainly, my
if anybody approaches this court, he has a right.
Certainly, my lord.
How many judgments you want of the Supreme Court on
I know, my lord.
On this court?
My lord.
Yes.
Absolutely correct.
So
my
where
lord.
is the rule?
My lord, I am unable to give you. I asked them. They provided me that with those 2 papers. Perhaps the person with whom I was contacting is not able to understand your lordship's query. I repeatedly asked him, he gave me that. My lord, be that as it may, my lord.
Who are functioning as Deputy Solicitor Generals. One is Rajdeep Mojumdar, another is Mr. Dhiraj Trivedi, and
there are 2 deputy solicitor generals and
Billodal Bhattacharjee.
No, Bilal is not.
He is not in the panel.
No, he is in panel, but he is not DSG, my lord.
He is not DSG.
Issue.
My lord, my
In spite of the order passed on 19 November 2025, rules relating to recruitment of Constable GD in Central Armed Police Forces within CAPFS is not produced. So, stop. Court is considering whether it is provided in the relevant rules relating to the selection process for filling up the post of Constable GD. Any provision is present, or any provision, any provision is present, or any provision is there relating to lifetime of the panel once prepared. Top learned advocate representing Union of India has expressed his inability to produce such rule. Stop. Mr. Dhiraj, next paragraph. For next paragraph, in order to adjudicate the issue involved in this writ petition, consideration of relevant provisions of the rules relating to recruitment of Constable GD in CAPFS is necessary. Next paragraph. Court requests Mr. Dhiraj Trivedi, learned Deputy Solicitor General, to appear in this matter. Stop. Additional Solicitor General, learned Additional Solicitor General is requested to regularize the engagement of Mr. Dhiraj Trivedi, learned Deputy Solicitor General, in this matter. Stop. Next paragraph. The learned advocate for the Union of India is directed to produce rules relating to recruitment of Constable GD in CAPFS.
In context to life,
Especially the life time of the panel prepared in this regard. Hearing of this matter stands adjourned. list the matter under the same.
Lord, I have already
further
submitted
consideration-
two papers, my lord.
Further
I have
consideration
attached
on
চিরে ভাই, একবার তো হচ্ছে। My lord, kindly note that, my lord, may kindly note that
10th December 2025. Stop. Learned advocate representing the petitioner is directed to communicate this order to Mr. Trivedi for taking necessary steps.
My lord, shall abide by the result, my lord, let one line be added, if my lord allows. That is
Next
my-
matter.
Item number 4.
Yes.
Item 4, my lord, I beg to appear for the petitioner, my lord. My lord, I have served upon all the respondent, my lord. But, my lord, affidavit of service, my lord, I undertake to file, my lord, in course of the day,
My
my
lord,
lord.
I am representing Respondent Food Corporation of India, my lord, FCI. We have not received the writ petition, my lord, so far.
Then how you are appearing?
My lord, we came to know from some sources.
FCI is the.
My lord, FCI is the sole respondent, my
Respondent.
lord.
My lord,
Food Corporation of India, my lord.
kindly allow 10 days.
New
time.
Delhi, Salt Lake office and Mirza Ghalibi Street, my lord. And Bajpayee. Matter, my lord, relates to, my lord,
Service is not complete. His matter relates to?
my lord, matter relates to, my lord, irregularity in the preparation of, my lord, preparation of gradation list, my lord, by the respondent authority concerned, my lord. Since 2014, my lord, the authority various time, my lord, prepared, my lord, the gradation list, my lord, and the name of the petitioner, my lord, slowly and gradually they were degraded, my lord. Whereas, my lord, the juniors as well as the same counterparts, my lord, they were promoted, my lord. So, my lord, after, my lord, submission of, my lord, the
Learned advocate representing the petitioners has prayed for accommodation to complete service of notice upon the respondents and file affidavit of service. Stop. Let notice be served upon all the respondents and an affidavit of service be filed. Notice be served upon all the respondents by 7 days and affidavit of service be filed on the next date. Learned advocate representing Food Corporation of India has paid for accommodation to obtain instructions. Stop.
10
Hearing
days
of
time.
this matter stands adjourned. List the matter under the same heading for further consideration on 10 December 20.
gratefully.
Next.
Item number 5.
I am appearing for the state.
Is which for the petitioner?
Five.
Yes.
The petition cannot be considered because my lord, my lord,
At the time of call, no one appears for the petitioner and no accommodation is paid for. However, state respondents are represented by learned advocates. Writ petition stands dismissed for default. Parties to act on the favor copy. Next.
Item number 6.
Lord, in this matter, I am petitioner number 1 to 4, Union of India. And my instruction, my lord, to take instruction from the department regarding this issue, my lord.
What is the issue?
The issue is that the person concerned, the ex-officer, my lord, commissioner, and OIC, EC, GS Polyclinic.
Yes.
OC, OIC,
YCC Chest Polyclinic.
Polyclinic. Every year,
YCC Chest
Ex-serviceman contributory health scheme.
health scheme. He appointed every year for as a contractual basis, my lord. But this year it's not considered. Respondent number 5 is considered because he is selected. That is why he is appointed.
That is why the
why he is
petitioner has
not-
grievance against selection of respondent number 5.
I'm not respondent number 5. I'm respondent number 1 to 4, my lord.
4 is the private party. 5 is the private party. He has been selected for the post.
Selected for that.
That is the grievance, subject matter of
That is the
grievance so
why
far
is-
petitioner is concerned.
Yes.
Have you served upon respondent number 5?
Yes, Lord.
How you have served? Show me.
Lordship, this affidavit of service.
When it was served, find it out.
It was served on 28th.
He has received on 28th November.
As per track report. Lordship, issue is that.
But that respondent number 5 has to be heard.
Lordship, if in brief I tell,
The fact is that there was a 4 vacancy for YCCHS polyclinic. The persons already
4 vacancy in
YC officer in charge, ECHS ex-serviceman contributory health scheme. The normally person maintain the polyclinic, overall in charge. There was 4 vacancy. The thing is that the petitioner in employment since 2023, 2 years already completed, but they, due to avoid the permanent status in every financial year, they fresh employment and extension was there. So out of 4, the 3 persons, they already employed just like petitioner as a YCC ECHS polyclinic, and they got extension because any contractual employee cannot be replaced by another contractual employee provided there is any efficiency issue or any adverse remarks. In case of petitioner, there is no issue, but arbitrarily the person, petitioner number 5 employed, that person retired from the same station, the appointing authority. That's why that person has been favored. And arbitrarily the petitioner name has been debarred from the list. That is the main issue. They used to get up to 65 years of
take instruction.
Just kindly give me instruction.
Take instruction and let me see whether on the next date respondent number 5 is represented or not.
Lordship affidavit of service.
Show me service of notice upon respondent number 5.
Baruipur. Respondent number 5 is Baruipur.
Five 5095 8 505 5 issue. Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Next paragraph. In spite of service of notice, respondent number 5 is not represented. Next paragraph. Client advocate representing. You are representing which respondents?
1 to 4.
Client advocate representing respondent numbers 1 to 4 has prayed for accommodation to obtain instruction. Stop. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on 10th December 2025.
Which date, Milo? 10th.
10th December.
They are wanted to 2 weeks time, Milo.
No, sorry. Sorry.
10 December.
Item number 7.
My lord, I am from the High Court Administration. Your Lordship, I am appearing for the petitioner. Your Lordship, the advocate engaged in this matter has some serious health issues.
Health issues?
Health issue. He will be traveling to Vellore tomorrow, Lordship. So I got instruction to make it an adjournment for 10 to 12 days, Lordship, for the treatment, Lordship.
At the time of call.
Along with this matter,
at the time of call, accommodation is paid for on behalf of the petitioner. On the personal ground, since the learned advocate is unwell. Stop. However, High Court administration, state and state respondents are represented by learned advocates. However, High Court administration is represented by Mr. Das and state respondents are represented by Mr. Sen, additional advocate general.
And I am raising a point.
Learned additional advocate general. Stop. Next paragraph. Considering the prayer made on behalf of the petitioner, hearing of this matter stands adjourned. How long you want adjournment?
Your Lordship, 2 weeks at least, Lordship. He will be traveling to Vellore tomorrow.
Hearing of these matters, hearing of the list the matter under the same heading for further consideration on 22nd December 2025. You raise your point on the next day.
Grateful, Your Lordship. Your Lordship, another submission, Lordship.
Yes.
Yes. Along with the same petitioner, along with this writ petition, he preferred another writ petition, which is WPA 24331 of 2024, but it has not been listed. So kindly, Lordship, tag the matter and hear it same day.
So let me see on the next date.
Grateful, Lordship. Grateful.
Next.
Item number 8.
Yes.
With relating to the same petitioner, my lord, another application is fixed on 3rd, my lord. It relates to, my lord.
At the time of call, no one appears for the petitioner and no accommodation is paid for. However, Union of India is represented by the learned advocate. Writ petition stands dismissed for default. Parties to act on the server copy. Next.
Item number 9.
I am for the petition. I am for the state respondents, my lord.
Yes.
Yes, my lord. Lord, the petitioner's father was actually an employee, government, and during his service tenure, he expired. And thereafter,
during his
service tenure, he expired.
Where father was working.
Father?
Where father was working.
I am just stating you, Lord. See. Under the respondent number 2, that is the block development officer Beldanga, 1 block, and was working as an OCM in the office of respondent number 2 prior to his death on
working as
OCM.
Full form?
Operator cum mechanic.
Mechanic. Operator cum mechanic. So if he is working under the block development officer in BDO office, then it's a government service.
Yes, government service.
So then how this writ petition is maintainable here?
I am not praying for any, but direction upon them, because inquiry was made on basis of.
What is your prayer appointment?
Appointment on compassionate ground.
Yes.
That is correct, my lord. But here I have filed this writ petition only for a direction that despite receipt of the representations on several occasions and even RTI application.
What is the prayer in your representation?
Representation that kindly communicate me. What
communication relating to?
What is the fate of my application?
Application for
compassionate appointment.
It's not maintainable here.
Milord, but they are not saying anything. Inquiry was made.
Please read section 15 of the Administrative Tribunal Act 1985.
Milord,
anything relating to recruitment.
Milord, I am not challenged that they have denied me service, but I have only prayed for that a direction be given so that what is the fate of my application, kindly communicate me. Your lordship kindly see in the prayer I have stated this thing only. Prayer similar.
To appoint the petitioner on compassionate ground.
That is
issue. Matter is heard in presence of the learned advocates representing the petitioner and the state respondents. Stop. Petitioner's father was working under block development officer, under concerned block development officer.
Respondent number 2.
As
my lord, operator cum mechanic.
As operator cum mechanic. Stop. After hearing the learned advocates, it appears that petitioner's father was holding. After hearing the learned advocates, it appears that petitioner's father was a government employee who died in harness. Stop. Petitioner has made an application for appointment on compassionate ground, and it is contended on behalf of the petitioner that his representation for appointment on compassionate ground is not being considered by the concerned respondent authorities. Stop. Where is the appointment letter of your father? Anything? No. Nothing. Stop. Next paragraph. In view of aforesaid scenario, it appears that a writ petition at this stage is not maintainable before this court. Stop. Before this court, and the same stands dismissed. However, this order shall not preclude the petitioner to approach West Bengal Administrative Tribunal with the same to approach West Bengal Administrative Tribunal on the self-same cause of action. Stop. Parties to act on the server copy. Next.
Item number 10.
For the writ petitions. But it's a question of promotion. Not the Coal India Limited had constituted an anomaly committee for the purpose of finding out the redress.
Again promotion. For a long period, I had to consider you one of your promotion matters. Mr. Gupta was appearing for Coal India. Yes.
Now, not in this case, not the.
How many petitioners?
24.
24 petitioners. Court fee
paid.
Where is the document relating to?
Please come to page 168.
Yes. Court fee paid.
Now, not the difficulty arose because the 2007 batch of.
Who is appearing for Coal India?
Lord, I am appearing for the Coal India, my lord. My lord, I have two proposals, my lord. If your lordship, my lord, directs an affidavit in opposition, we would like to file an affidavit in opposition. Otherwise, my lord, if my learned senior friend is praying for an interim order, my lord, then my lord, I would my lord, seek my lord 7 days, my lord, accommodation, my lord. Because my lord, so far as this matter is
take a uniform stand. If prayer for interim order, then I would pray for 7 days time. If no prayer for interim order, then let the matter be.
But I have a third proposal.
This is.
I have a third proposal.
This should not be countenanced.
But the difficulty is, in so far as this matter is concerned,
it's a matter of taking chance.
No, I'll just indicate. Not your lordship may not have to decide it at this stage. Now, not the dispute arose because there had been en bloc promotion of reserved category candidates, irrespective of the number of vacancies reserved for them. Now, not this has resulted in the unreserved category candidates of the same batch being deprived in the promotional avenue. Because not regardless of vacancy, they have been promoted. Now, an anomaly committee was constituted. Now, please come to page 168 and 169 in the second volume.
Yes, 168, 169.
The conclusion. Please see the conclusion.
This is the report of anomaly committee.
Conclusion. Considering the pros and cons of the two options, the committee is of the opinion that though the aggrieved unreserved executives, not our clients, were not treated at par with their junior reserved executives in providing notional seniority in E5 grade citing reservation, the junior SC/ST executives of 2007 departmental batch, not departmental batch are the promotees like us, were not promoted against reserved vacancies. Rather, they have been promoted against supernumerary vacancies. Further, such differentiation has not been specifically mandated by any reservation rule or policy. Rather, it is an administrative decision. Moreover, the reserved and unreserved candidates were treated as separate groups for administering consequential promotional or notional seniority benefits only in mining discipline due to promotion of only junior or SC/ST direct recruits, whereas in other disciplines, wherever junior direct recruits promoted, it was a mix of both reserved and unreserved candidates or only unreserved candidates. Such differential scenario existing only in mining discipline is considered to be a demotivating factor compared to other disciplines. In view of the foregoing, the committee recommends to provide notional seniority to the 2007 departmental mining executives subject to other conditions of promotion like clearance, eligibility conditions, etc. as under. Notional seniority in E5 grade with effect from 19/3/2018 to the aggrieved set of 122 2007 departmental mining executives who are currently working in E5 grade with effect from 21/2020. Notional seniority in E5 grade with effect from 6/4/2018 to the set of 103 2007 departmental executives who are currently working in E5 grade of mining second class channel with effect from 12/3/2022. Consequential notional seniority in E6 grade with effect from 29/3/2022 on subsequent DPC record.
So the notional benefits have been decided to be extended. Now, how you are praying for implementation of this? But this is a report of 2nd January 2024. Why you are coming after such a long time?
This was only after disclosure in RTI in 2025.
Then let it be decided on a figure. Mr.
That it's their own constituted committee, not if this could be finalized at least.
The promotion order which is
Affidavit of service filed on behalf of the petitioners is taken on record. Next paragraph. Petitioners are officers or employees?
Executives.
Petitioners are executives of Coal India Limited seeking benefits of promotion based on a report.
We have been promoted, we only seek notional seniority. We have
Already promotion was given.
So it's a restoration of notional seniority apropos the juniors.
আচ্ছা কি বলছিলাম দেখো না seeking notional benefits based on a report dated 2nd January 2024. Stop. Mr. Soumya Majumdar, learned senior advocate representing the petitioners, has drawn attention of this court to said report dated this is the report dated 2nd January or 12th January?
This is 2nd January 2024.
2nd January. 2nd January করে দেব 2nd January 2024 wherein certain recommendations are made for extending notional benefits in favor of executives working in Coal India Limited. Next paragraph. Coal India Limited is represented by learned advocate. Stop. Considering the prayer made in this writ petition, court finds the issue needs to be decided on exchange of affidavits. Stop. আচ্ছা এর আগে একটা লাইন অ্যাড করে দাও. It appears from the submissions made on behalf of the petitioners that petitioners have already been favored with promotion, but they are seeking benefit of notional they are seeking notional benefits. তারপরে ওটা করে let affidavit in opposition to this writ petition be filed by 3 weeks from date. 4 weeks it will be within vacation.
Difficulty that I have, my lord, discussed.
By 3 weeks from date, stop affidavit and reply thereto, if any, be filed by 2 weeks after ensuing Christmas vacation. Stop. Petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits. Great. Next.
Item number 11.
I am and the petitioner is initially appointed as a construction engineer at Bridge and Roof Company.
Yes.
Petitioner was initially appointed as a construction engineer in Bridge and Roof Company. This is under the central governments. Subsequently, thereafter, petitioner applied for the promotion. For a long time, they are not granting the
Executive, what is the post?
The post now he is promoted in the grade E2 engineer, but his desire for the E3.
Grade E2.
E2. But he is eligible for
executive engineer.
Yes.
Just a minute. Grade E2 executive. Now, what to which post he is seeking promotion?
Now he is working in the post of the deputy manager, grade E2.
So he wants promotion to E2 executive engineer.
E3.
Presently working as
the deputy manager, grade E2.
E2.
Yes.
So next higher post is grade E2 executive engineer.
Yes.
From the post of deputy manager, grade E2. Yes.
Subsequently they're not considered their his
You are
prayer.
representing Bridge and Roof. Yes.
Prayer, my lord, the writ petition was moved. Honorable Court was pleased to direct to consider the representation and pass the resin order. My lord, subsequently, my lord, kindly page 78 is the impugn order passed by the authorities.
Page 78.
Page 78, my lord, the last portion of the order.
It order starts from which page?
My lord, order starts from page 76. 76 onward.
Why you are coming after such a long time?
My lord,
2022 order.
My lord, this order has been challenged before this honorable court. That writ petition is pending. But subsequently, there is another cause of action is created, my lord. On the basis of performance, my lord, the promotion has been granted by the authorities. My lord, there is the annual report. On the basis of the report, the promotions would be considered. And kindly see the preference report of the authority, which was, my lord, I have annexed the final report.
No, now this order dated 25th April 2022, what was decided?
My lord,
In this order dated 25th April 2022,
my lord, this is the impugned order that has been challenged.
in this writ petition?
No. My lord, this
In the
is
previous
the
writ
another writ petition is pending.
Last-
My lord, your lordship kindly take up the matter along with this writ application. My lord, the both of the writ application would be heard, your lordship.
Has not yet become E3, and as such, he cannot be promoted to grade E3. As a- So you sought for promotion to grade E3.
E3.
Grade
now-
E3.
Yes.
Now that was denied.
Denied.
That was not allowed. Now whether you are seeking promotion to grade E3.
Grade E3, but
So you are saying grade E2 executive engineer?
my lord, this is now at present I am working. My lord.
No,
present
at
I am
present you are working as deputy manager grade E2.
E2.
And you are seeking promotion to grade
But
E2, E2.
E3, my lord.
E3 executive engineer.
Yes.
So that has been turned down in 2022.
Yes.
So why you are coming in 2025?
There is another cause of action, my lord, assessment report. But kindly page 84, my lord. Well, what is the, my lord, the fact is, my lord, as per internal report, my lord, there is the marks has been graded out of 100. My lord, on the basis of, my lord, the preference, the promotion should be calculated.
Officer reported upon. Section 2. Yes.
Yes. My lord, there is the three part. First of all, my lord, the reporting officer, then my lord, the reviewing officer, thereafter accepting officer, and final accepting officer, then chairman. There is the categories, my lord. Now kindly see the marks has been allotted where the petitioner is working under whom.
So you are challenging annual performance report.
Or kindly see page
So where
89.
is that annual performance report?
But this is the for assessment year 1st April 2024 to 31st March 2025.
Yes.
But kindly see, my lord, page 89.
Page 89.
Last portion. Or the deputy managers, this is the petitioner Anirban Das.
Chairman and manager.
Section 9, my lord. Section 9, annual performance assessment report.
Where it is financial page 89.
Yes, my lord, the
accepting authority, then Rajesh.
First, my lord, the deputy manager. This is the petitioner, my lord.
Page 89.
Page 89, my lord.
Is a final accepting authority. Heading.
My lord, top portion, but below, my lord, the section 9, annual performance assessment report, my lord.
Section 9, yes,
Yes,
annual
yes.
performance assessment, yes.
But the deputy manager, this is the petitioner, my lord.
Yes.
Yes, this petitioner is working under, my lord, the Rajesh Kumar Mondal, the senior manager. But senior manager granted out of 100, 79.64. Then, my lord, the Sandeep Rai, head of the, my lord, the project, he is also granted 79.64. And my lord, thereafter, executive director, my lord, the Taposh Saha, he is also granted 79.64. But this report, my lord, is sent to the higher authority on the basis of their report, then giving the marks, my lord. But kindly come to, my lord, the Ravi Kumar, she also given 68. Then, my lord, chairman is the final authority to decide the giving the marks on the basis of the marks given by the officer where the petitioners is working. He is given 49. But there is no expression. That's why my preference is, my lord, the only fair. Well, if the, my lord, the fair has been granted, my lord, I will never any promotion in future, my lord. But this is really
No, you will not get any promotion in future. No, that is not correct. You will get promotion if subsequently you get better assessment.
No, my lord, subject to lordship correction. My lord, they officer, but there is no connection between the petitioner and the chairman. On the basis of report,
Everywhere in the case of promotion, even in the case of judicial officers also, this system is prevalent.
yes, my very
So outstanding, very good, good, fair, poor.
yes.
Now, if the assessment for a generally preceding 3 years assessment is considered, it is called annual confidential report, and based on such assessment, generally promotion is one of the factors. Now, if anybody is below good, then he will not be considered for promotion. So far, your organization is concerned.
That will be taken as a negative in the last 3 years.
So what assessment a candidate requires or an employee or officer requires for being promoted to the next higher post?
Promotion policy.
Is it good or very good? Where is the provision? Now the grievance of the petitioner is that since petitioner was assessed fair, which is below good, for the year 2024-2025, he was not found fit to be promoted to the next higher post. That is the sum and substance of the case of the petitioner. Now, what is your norm? So far promotion is concerned, in annual confidential report, what assessment is required?
But the benchmark, I have to take instruction. What is the benchmark? But the what the
No, I want that what assessment is required for the preceding 3 assessments.
Yes, the minimum which has to be there.
Yes.
That I have.
What assessment is required?
But
wait. Now you have to take instruction.
That instruction.
Very well, take instruction. Come back. Not today.
one thing,
Yes.
subject to lordship. The chairman is given 49. There is no.
So initially, other authorities has given 76.4.
Yes, that is my contention. On the
how
basis
this
of,
assessment was made?
yes, another thing, now after filing the writ petition, the authorities are not allowing to sign the register.
Huh?
Not allowing to sign in the register. Not allowing to giving the any word.
There is a transfer order, my lord.
Transfer is, now after filing, transfers, the Arunachal Pradesh to Meghalaya. Each and every month is giving transfer. This is because
when transfer order was passed.
Kindly see page 97, my lord.
Page 97. Just
page 97.
Page 97. No, it is 14th October 2025.
Yes.
Prior to filing of the writ.
No.
Yes.
After
writ petition was filed on 24th of November. Otherwise, you would not have used this document in your writ petition.
No, I have page 95 and I have made the.
This is a better posting than Arunachal.
I have no objection.
Arunachal to Meghalaya.
I have
your state.
My lord, I am from the Hooghly, my lord. Actually, what happened? There is no issue.
It is closer to Kolkata, nearer to Kolkata than Arunachal. It is Meghalaya.
Yes. But from Arunachal to.
Very well, you obtain instructions. Transfer is not the issue before this court.
Yes.
So court will not delve into transfer issue. But what is the norms relating to assessment or annual confidential report, and what assessment is required in order to become eligible to be promoted to the next higher post, or to be considered for promotion to the next higher post?
One thing, my lord, not to disturb the petitioner, because my lord, they are.
No, promotion is not an.
No, I am not seeking any stay out from the promotion, my lord. Not allowed to sign in the register. That is why.
That is related to the transfer, my lord.
Yes.
That is related to transfer, my lord.
If you are transfer.
I am ready to join.
Join the transfer post.
Yes, I have no, but not allowing to, my lord, to sign in the.
Because perhaps you are trying to join in your present post.
No,
in the transfer post.
Not
in the transfer post, petitioner is not being permitted to join.
No, but I am not release order. No release order passed till today.
Then
Well, he has been transferred. My lord, he
Let
has
them
to-
file a report.
Then there is no release order.
My lord, kindly see the last line of that page 97.
You are advised to report to Northeast. Yes.
He is directed to report there to Mr. Bishwi Pal, Deputy General Manager.
But a release order is necessary from your present post. Otherwise, how you will go straightway go from Arunachal to Meghalaya unless until a release order is there. Show me where is your release order based on this transfer order. Even after transfer order is passed, unless until reliever comes, transfer order is not given effect to.
But when he is
Where is your release order? Pass one line release order. With the said release order, he will go to Meghalaya and join.
in the transfer order itself, when he is advised to report my
Yes, but with the release order, he has to go. Where is such release order?
he has been transferred with immediate effect. My lord.
Yes, but where is the release order?
But this order of
If
transfer,
without release order he goes to Meghalaya from Arunachal and if he is not allowed to join,
well, he is already directed to report to particular.
but there is a
person.
concept of release order in the case of transfer, which goes to show that the petitioner service is without any blot,
But I believe because my lord,
without any blemish.
no, that is
Yes, so that's what release order is necessary.
but he has been transferred with immediate effect and reported to join. So I
Yes,
believe
yes, that will be given effect to. But where is your release order? There should be a formal release order from Arunachal.
But, very well, but I will be coming back with this instruction also, my lord.
But since you are working in Arunachal and is to be transferred to Meghalaya, then why you have filed this writ petition here? What is the territorial jurisdiction?
But this the head office is one of
Is in Kolkata. Issue a release order. Allow him to join.
I will take instruction on that also. But it seems, my lord, this
Issue.
order of transfer itself, my lord.
Petitioner, an affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner is presently working as deputy manager grade E2 in Bridge and Route Company and seeking proper assessment of his performance for the year 2024-2025, which would make him eligible to be promoted to the next higher cadre or to the next higher post, that is executive engineer grade E3. Stop. Next paragraph. Attention of this court has been drawn to page 89 of the writ petition, wherefrom it appears that chairman and managing director awarded 49 marks, though other authorities subordinate to chairman and managing director awarded higher marks to the petitioner in order to assess his performance for the year 2024-2025. Stop. According to the petitioner, awarding of 49 marks for the year 2024-2025 is erroneous. Next paragraph, it is also submitted that petitioner was transferred Meghalaya as deputy manager from Arunachal Pradesh, but no release order is issued till date enabling the petitioner to join the transferred post. Next paragraph, learned Mr. Mukherjee, Mr. Chatterjee, Victor Chatterjee, Mr. Victor Chatterjee, learned advocate representing Bridge and Roof Company, has prayed for accommodation to obtain instructions. Stop. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on 10th December 2025.
Item number 12.
Mr. Trivedi, in one matter I have appointed you because I want to know the selection rules relating to selection for the post of Constable GD in Central Armed Police Forces, because the issue is whether the panel is subsisting or not. Now, what is the lifespan of panel? That was the query of this court. Now, in spite of giving direction to produce the rules, especially the rule relating to lifetime of the panel, today only an executive communication is produced before me, and the learned advocate representing Union of India has expressed his inability due to non-cooperation from the department. So that's why I have directed that Mr. Trivedi will appear and your engagement will be regularized.
I shall ensure.
Yes.
Lordship, but just one, I'll be cutting a sorry figure if my lord has made it returnable on the 4th and 5th, my lord. Otherwise, next week, my lord, I am.
No, 4th, 5th, this matter is not fixed.
I'm great.
All matters are fixed around 10.
I'm great. Then,
10
my lord, I shall.
yes.
Item number 12.
My lord, item 12, my lord, I am for the petitioner. My lord, list this matter, my lord, after 5th, my lord, my lord,
Why?
service is incomplete, my lord. My lord, service
Yes.
incomplete, my lord. My lord, service is incomplete, my lord, list this matter after 5th, my lord.
Then why you have stated in your presentation form that matter is to be listed on 1st of December at the time of filing on 26th of November? Because this court follows the procedure that in terms of the presentation form, matters will come in the list.
Kindly, my lord, fix it.
So why you have not, and by already 1 month has passed, why you have not been able to complete service?
My lord, it is my clerk fault.
Yes.
My lord. My lord, it is my clerk fault, my lord. Kindly fix it, my lord, after 5, my lord, list this matter, my lord. Kindly, my lord.
State of West Bengal Assistant Vigilance Officer. Port Trust. You have filed this writ petition under which group? No group is written Group 6 service. You have not served upon the Kolkata Port Trust.
My lord, sir, my
It
lord.
is nearer to this court.
My lord, it is my clerk fault, my lord. My lord. Kindly fix
Yes.
this matter, my lord.
Where the Kolkata Port Trust office situates.
My lord, list this matter after 5th, my lord. I will.
Say walking distance.
My lord.
So then why it has not been served? Are you the advocate on record?
Lord, no, my lord, I am not advocate on record. I am led by Mr. Tanmay Bosu in my senior.
Yes.
I am led by Mr. Tanmay Bosu.
Who is Ombika Shashmol?
Lord, he is one of our.
Where is Tanmay Bosu?
Lord, he is not present here, my lord.
Where is he? Taking rest at home.
No, my lord.
Then?
He's on the way, my lord.
Yes.
He's on the way, my lord. He's in another court, my lord.
In another court.
My lord.
So why it has not been served?
Lord, it is a clerk
Kolkata
fault.
Port Trust is just 6-7 minutes walking distance from here. The writ petition was filed on 26th of November.
Lord, I am beg to pay apology, my lord. List this matter after 5th, my lord. We'll serve in the meantime, my lord. Kindly, my lord. Kindly.
Not today.
My lord.
Tell your senior to appear tomorrow.
My lord.
It will appear tomorrow. Oh, yes. Yes, call the list.
Item number 13.
My lord, I am for the petition in this matter.
Lordship, I'm appearing for respondents number 1, 2, and 4, and 3 as well, but 3 is in a formal capacity. There was a direction upon us to file a report. Our signatory authority will be joining to this week itself, so we'll be able to file it this week. But because your Lordship was keen on the engagement letters, I have brought those and I can furnish the court right now.
Let a report be filed in that event.
Let the report be filed and because they are pressing the time. No, Rashid, the only thing is that if they can produce the contract,
just in
terms, then একটা copy আমার। Give me one.
Yes, I can.
Issue.
Lordship,
Joint advocate representing Air India Airport Services Limited has prayed for extension of time to file report in terms of the order dated 6 November 2025. Next paragraph, petitioner is represented by the joint advocates. Next paragraph. Time to file report in terms of the order dated 6 November 2025 is extended by 7 days. List the matter under the same heading for further consideration on 8 December 2025. File report, file report. Take it back. File it on the next day.
My lord, matter is coming on 8th December.
Yes.
My lord, only one thing, my lord, 8th and 9th. I have
Yes.
some personal difficulty. Can it be posted on 10 or 11?
10 December. 10 December.
Item number 14.
My lord, may I get the last occasion your lordship directed me to deposit deficit court fees.
Yes.
Deficit court fees already been paid.
Yes.
The other day, my lord, I submitted before your lordship the petitioners at the
use microphone. Use microphone. Yes.
The petitioners before your lordship of the NVF, National Volunteer Force, who retired from their service and got ex gratia payment, but that payment was delayed. That now my client is seeking for interest. I made representation.
I have passed an order few days back.
Yes.
Granting-
That thing, my lord,
and
up to the honorable
similar-
court, my
No,
lord.
I have passed an order. Similar order I don't record. This
Here,
court has-
here,
then
where is that order?
in respect of all the petitioners, my lord, whatever my lord is honorable court may decide, but only in respect of petition number 9, 10, and 11, there is a my lord gross suppression.
What suppression?
They have from the post, they have already been taken and absorbed in a permanent employee as Ogrogami during this. But that thing and for that,
whether they have retired.
For that, they have retired and they have got their admissible retirement benefit except pension since 10 years that deficit that could not complete. But other, my lord, that thing that
respondent petitioner number?
Yes. Only, my lord, just one paragraph of my instruction, it will, my lord, suffice, my lord, that
these are the petitioner numbers
9, 10, and 11. Starting from the, my lord, third paragraph, starting with the applicants were paid admissible amount of one-time ex gratia.
Paragraph 3, page 2.
No, my lord, very first page, that the second paragraph. Yes, the broad one.
So now they are working.
No,
permanent
my lord,
pool.
this early period that except retail benefit, my lord, perhaps they have retired from that agrogamy post also. And here, page 5, paragraph 2 of the REIT application.
There is information in the seat. So respondent number, petitioner number, I am asking you, petitioner number 9, 10 and 11 are not entitled to get ex gratia because they were paid, received 50,000 each as one-time ex gratia as agronomies because they did not come under the purview of eligibility of pension and others determined benefits except payment of leave salary. So why they have joined along with rest of the petitioners?
But then in many other
I have
cases,
no instruction, my lord. Then except those persons, others may be allowed.
Do you have the copy of this order which I have passed?
no, my lord, I have, I was under that.
Now the I granted 6% interest on ex gratia from the date of from the date following the next date of retirement till the date of payment.
Yes. So the only difficulty in many other cases from the honorable court that misleading this type of
they are to be excluded from the area of the
but that we could not identify, but here we have identified that these persons are, but here paragraph 2 says all have retired from NVF.
Document in support of putting in deficit court fee is filed today and same is taken on record. Next paragraph. There are 12 petitioners who have jointly prayed for similar benefits of interest on one-time ex gratia, which was paid to them after their retirement. Stop. Petitioners were engaged as stop. It is submitted by the learned advocate representing the petitioners that they were engaged as volunteer in National Volunteer Force within bracket NVM. And they retired on different dates. But after their retirement, they were paid ex gratia, one-time ex gratia, belatedly. And as such, petitioners are entitled to receive interest on delayed payment of ex gratia. Next paragraph. Such submissions made on behalf of the petitioners is opposed by Mr. De, learned advocate, representing state respondents, to the extent that petitioner numbers 9, 10, and 11, though were initially appointed as volunteer in national volunteer, a volunteer in NVF, but subsequently they were appointed on substantive basis as agrogami in WBNVF organization. Stop. It is further submitted that since they were engaged in different posts at the time of their retirement, petitioner numbers 9, 10, and 11 received different benefits which are not payable to the or which are not payable to retired volunteers of NVA. Stop. Therefore, these petitioner numbers 9, 10, and 11 are differently situated and they ought not to have joined along with rest of the petitioners claiming interest on ex gratia. Next, stop. It is also submitted that there is suppression of material facts so far petitioners number 9, 10, and 11 are concerned, and they are not entitled to get the benefit of interest. Next paragraph, learned advocate representing the petitioners submits that excluding petitioner numbers 9, 10, and 11, rest of the petitioners are entitled to get the benefit as claimed in this writ petition. Next paragraph, having considered the respective submissions made on behalf of the parties, the writ petition stands the writ petition stands dismissed in respect of petitioner number 9, 10, and 11. However, claim of other petitioners is considered by this court as it is submitted that in spite of their retirement, they were paid ex gratia not within reasonable time. Stop. It is indisputable that there was delay in releasing ex gratia in favor of other petitioners, conferring right upon those petitioners to get interest on delayed payment of ex gratia. Next paragraph. Accordingly, concerned respondent authorities are directed to pay interest at a rate of 6% per annum on ex gratia from the date following the date of their from the date following their respective date of retirement till the date of release of ex gratia within a period of 8 weeks from the date of communication of this order. Stop. Next paragraph. Since no affidavits are called for, allegations contained in these writ petitions are deemed not to have been admitted. Next paragraph. Writ petitions stands disposed of. Urgent xerox certificate.
Much obliged.
Next.
Number reference. That your lordship already.
Is that I did not do not remember. I have tried to search it out, but I did not find it.
Yes.
Item number 15.
I came up with a very ordinary prayer for consideration of my representation. It is with regard to the appointment for the post of judicial member.
Post of
judicial member in the Railway Claim Tribunal. Railway Claim Tribunal. There was a notification all over the India. There are certain places.
Judicial member in Railway Tribunal.
Railway Claim Tribunal.
Claim Tribunal.
So the appointment notification was declared all over the India. All the High Court's register was addressed and aware of the notification. And there is a condition stipulated that anywhere in the India, the members who will be finally selected, they will be appointed. So it has a vast effect throughout the India. Now, I am not asking anything at this stage. I have made a representation categorically saying what is your criteria. I was initially selected in the initial shortlist. My name was item number 47. Out of 92 candidates, there was a shortlist of 71 candidates. I am coming to the relevant pages. 71 candidates. Out of 71 candidates, my number was 47, and there were certain members of the judiciary, retired judicial officers, as well as the advocates, having practicing experience of 10 years. My number was on the top among the advocates. Thereafter, I could not see my name in the next shortlist. The shortlist of 71 candidates out of 92, again another shortlist was made, that is for 32 candidates. From 32 candidates, my name was missing. My lord, in this argument, initially was taken up by the earlier court. One point came from the bench that how far the application is maintainable, so far the territorial jurisdiction is concerned. And the entire argument is based on that. If my learned friend wants to press that point of territorial jurisdiction, then I have to argue.
Yes, this point was previously taken.
So, my lord, in this, kindly look into.
It was recorded in the previous
Yes,
order.
that is
That
why.
where is your with regard to territorial jurisdiction?
That is why my point is argument subject to correction of the law.
Show me your representation.
Yes, 32, page 32.
Page 32.
No answer to that. 32 starts from 32. I say that my.
So all the respondents are stationed outside the jurisdiction of this court.
Yes, my lord. In this case, my lord, I will
one
show.
more point.
My lord, let me submit first, my lord.
Yes, I will hear you. Yes.
আপনার একটা ভুল হচ্ছে ওই জন্য আমি বলছি my lord will kindly appreciate whenever judicial appointments are made in any tribunal, it is not made by the department. That is a search committee which is headed by an Honorable Supreme Court judge. Here, my lord, Honorable Supreme Court judge was the chairman of this committee. Initially, what happened was there were 71 candidates who were appointed, who were applied. All their qualification, eligibility were in order. Subsequently, there to lordship, 32 candidates after the IB report and other essentially they were shortlisted. They were called for interview. In those 32 names, he was not there. Now, my lord, what I am humbly submitting is that is first point. Second is, my lord, what instructions we have got, my lord, is that that search committee has to be made a party because otherwise, my lord, we have nothing to do. Railway, what railway will do? আমি দিচ্ছি আমি এখনই দিচ্ছি আপনাকে এটা দেখুন আমি আপনাকে দিই my lord will kindly take up the first page is my lord letter to me, second page my lord background of case like lordship will kindly take up my lord will I apologize for the print quality my lord has talking my lord will kindly see that this is the committee my lord the technical this is the search and selection committee which is SCSC.
Where second page
lordship and background of case, that heading lordship, the first paragraph, paragraph 3 lordship will kindly state.
Yes, yes.
Now, my lord, this is the committee, my lord, which is responsive for this selection. Now, my lord, as far as railway is concerned, my lord, railway cannot be a party to selection for judicial officers because it's a neutral tribunal which is adjudicating claims. And here, my lord, the railway has been made party, my lord. Railway cannot do anything about this. The eligibility criteria, the suitability criteria, everything is, my lord, to be decided by this SC committee. এই লিস্টটা কবে বেরিয়েছিল? লিস্টে 32 যে লিস্টটা ছিল এটা তো আমি দেখেছি কিন্তু সে কবে বেরিয়েছে আমি আছি।
Now, it is not a case. So, as it appears from your submission that it is not a case of territorial jurisdiction.
My lord, it is a case of territorial jurisdiction. That is one, my lord. Then after
Because
that, when
in one way of looking at the issue involved in this writ petition is that the search and seizure, that the search and selection committee was not arrayed as a party respondent, and court can grant leave to the learned advocate to array search and seizure the selection committee as party respondent.
Lordship,
Provided this court has territorial
My lord.
jurisdiction.
And my lord,
If
one
this
more
court
point,
does
one
not
more
have
point, my
territorial
lord.
jurisdiction, question of
Yes, my lord.
entertaining this writ
Yes, my lord.
petition does not arise.
I'm grateful, my lord. And my lord, third point, because as my lord's officer, I'm just sharing three limbs of my argument which comes to my mind. Now, my lord, initially 32 candidates were shortlisted. That was way back in 2024. He should have challenged that. Now, my lord, 32 candidates selection have been made
Out of 76.
Yes. When 32 list was, then he was not there. Then he waited for the 16 list to come out who was selected. Then he comes up with a representation in 2025, my lord, when the posts have been filled.
When post was filled?
My lord, it was filled, my lord. My lord will kindly see. My lord will kindly come to P3 first, my lord. That is at page. If my lord kindly comes to page 30. My lord, to assist lordship, may I start from page 26? 27 is the first list, my lord, where all the people who had applied having the requisite eligibility.
Page 26.
27, lordship, to be more precise.
Yes, page 27.
Lordship, this is the name of 71 candidates, where at page 29,
name of the petition is there.
Lordship.
47, right?
আমি assist করে দিচ্ছি স্যার। তারপরে
Page 29, 47.
Lordship has got it. Page 29, my lord will kindly come.
Serial number?
Serial number 47.
Yes.
Now, my lord, here, my lord, these are the name of the candidates who had applied, my lord. Shortlisting was at page 30 by the SC committee, which has been stated in my my lord instruction that it was on the suitability criteria, IB report, everything. IB report is also one of the criteria, lordship. Now, my lord, after that, 32 candidates. Now, my lord, I cannot advise my learned friend, my lord, but then this 32 candidates, when they were shortlisted and the petitioner's name did not appear there, it was high time for him to come to this honorable court. Whether
when the shortlisting was made,
my lord, this was done in 2024, my lord.
Where from you are getting this?
My lord, I'll come. My lord, he has stated that 24 I can gather, my lord, from the slash which has marked there. But exact date, if my lord kindly takes up the notification number at page 30, file number is 2024.
3.
Lordship, 30, lordship.
30.
My lord, date is there, my lord. If I want to assist, my lord,
please assist.
Kindly see.
Yes, 30.
30 at the bottom.
Yes, tell me.
Generated from office, e-office by so and so.
27th
June up to 24.
So June 2024, lordship, even by going by that. Now 2024 June, if this comes up, his allegation, his name did not appear there also.
And when appointment was made?
Appointment was made thereafter. 16 candidates were given, Milan. That was on 27/6/2024, page 31.
Same day. First list and second list.
Oh,
same
out of 32, 16
16
candidates are
candidates
appointed
selected.
on 27 June
Yes.
2024.
Representation is being made on 7/2/2025 after 8 months.
What remains?
Territorial jurisdiction, my lord, I am still holding my fort.
So far, my lord, I have.
What remains?
My lord, so far, these representatives, they have not stated anything.
What
When
Is not at all a representation, it's a legal notice.
Even after that, the post was vacant. That is
After selection, what remains?
thereafter another notification made.
That is not the subject matter of this
Now, we have
petition.
stated that if it is not exhausted, my name was, that notification is.
That you can, there's if another notification is there, you have to initiate, then there will be a fresh selection process and the application is to be made afresh. Court will not delve into the subsequent notification issue.
Only thing I require, my lord, here, my lord, a very short remedy. Let them say answer why I
No,
have not been
court will not pass any absurd order
No.
directing the authority to consider after all appointments are made.
Whether the appointment was made and when it was made, it is nothing on record. I have no
And this
reply.
writ petition was filed on 10th March 2025.
Notified.
When the final list was prepared on 24th June 2024.
When the appointment was given effect, that is not anywhere disclosed to the petitioner. That I want to know.
He is not.
That is not.
Sir.
My ad alteram partem is there. I could not get any answer to my request. That is only request. They can easily reply.
No, in the case of selection process, unless and until you make out a case that it is a case of illegalities, question of audio alteram partem does not arise, because if there is no provision in the selection process that the result is to be published, the result will not be published. This is final list was published. It was on the website, must have been. It was on the website.
My lord,
Then
my only submission is that your lordship will see both the list. First, man, kindly consider the list once again. Well, first list is page number 30, page number 29. I was among there was earlier persons are all.
Mr. Trivedi, how long this panel remained valid? This page 31.
My lord, that panel lordship, what happens, my lord, because then I have to get the entire thing, my lord. What I could gather from my instruction and from this petition, my lord, there is a stumbling block. Two things, my lord. First is jurisdiction. 226(2), my lord, comes, my lord, as a rock of Gibraltar. Secondly, lordship, this is.
But is it not a case of part jurisdiction?
Yes, yes.
My lord, part jurisdiction, if
226,
everything. My lord, I'm only on that, my lord. But has fallen from lordship. My lord, that is my first contention. My second line of defense was what I said, my lord, that it's a search committee, my lord, which needs to be made a party. Third, and then coming down to my on the merits, lordship, 2 points, my lord. Suitability and eligibility, my lord knows, my lord Justice Victoria Gauri's case, recent Supreme Court judgment.
Yes.
We are selecting judges for a tribunal which has nothing to do with railways, save and except that I'm a party litigant there. Now, this is a particular selection process where railway cannot be asked regarding any question as to what was the criteria of suitability.
So this
Search cum selection committee.
Which is every
search cum selection committee.
Yes, headed by Honorable Supreme Court Judge.
Was not constituted by railways.
No, it cannot be. Because my lord will kindly appreciate anything under the Companies Act, NCLT, established by, if Company Acts is taken into consideration, lordship will kindly appreciate it is always by and there was a case, lordship, where I fought before the Honorable Division Bench of this Honorable Court, where it was said that even the infrastructure to these tribunals should not be allowed by the concerned departments.
First, you demonstrate that how part
And one more point I would
cause
just,
of action arise within the jurisdiction.
I'm coming to that.
Because all the authorities are located, their offices are
Yes.
outside the jurisdiction of
My
this
lord,
court.
here, my lord, you will also rightly.
How
pointed
the
out-
part
Yes.
accepting your residence is in Kolkata.
I'm just.
How the part cause of action arose within the jurisdiction of this High Court.
Your lordship has rightly pointed out Article 226(2) is the answer. Kindly come to page number 18. That where does this notification ultimately affects? Kindly see the first paragraph 1. Railway Claim Tribunal is statutory authority established under the Railway Claims Tribunal Act to hear various cases appeals under the Railway Claims Tribunal 1987 here. So headquarters is situated at Delhi and its 23 regional benches are situated at 50 locations. One each at Chandigarh, Allahabad, Lucknow, Gorakhpur, Kolkata, Bhubaneswar, Patna, Ranchi, Secunderabad, Bhopal, Nagpur, Bangalore, Chennai, Ernakulam, Amravati, Ahmedabad, Jaipur, two other each at Delhi. And
Page
18.
Lordship.
I'm coming
80? 18, 18.
18. This is the nature of the notification. The railway claims, page 18. And this is the first paragraph. It was widely circulated throughout India. Subject to correction, my lord. A judicial, last line, a judicial member upon selection may be posted anywhere among these locations. And these are the seats. And these are the places is about to be affected by this notification. By this notification. Single notification is a comprehensive one regarding the appointment in various places of the tribunal and including Calcutta. Thereafter, my lord, kindly look into the second one. My learned friend had pointed out procedure for selection. The search cum selection committee, page 4, 19. Page 19. Procedure for selection, 91st paragraph. The search club selection committee constituted under the Tribunal Reforms Act for recommending the names for appointment to the said post shall scrutinize the applications with respect to the suitability of the applications for the post by giving due weightage of the qualification, experience of the candidate and shortlist candidates for conducting personal interactions. After that, my lord, final selection will be done.
You have applied indicating that you want to be appointed as judicial member, of claim tribunal in Kolkata.
My lord, it is, my lord, within the notification, they can be posted
Anywhere.
Anywhere. They can be posted, but these are the seats, including Calcutta. The seats of tribunal here.
Yes.
They will be affected. Then, my lord,
Railway Claims Tribunal.
Calcutta.
And it is stated that headquarters situated at Delhi, and other 20 locations, including Calcutta.
And
Kolkata.
This place will be also affected.
But you can be appointed anywhere.
Anywhere. Second, that is why it is comprehensive. Second one is that where does it circulated? Kindly come to page number. Notification was circulated.
In your application, you have not indicated that this is application confined to Kolkata.
No, anyway, I cannot.
There was no scope at all.
No scope at all. But kindly come to page 17. All the Registrar Generals were informed. Kindly, Supreme Court of India, High Court of Allahabad, High Court of Andhra Pradesh, High Court of Chhattisgarh, High Court of Delhi, High Court of Calcutta. So everywhere they are in.
Now, how part cause of action arose within the territorial jurisdiction of this court?
The order, the notification, I will not say the order, is a notification. It affects the appointment of the Calcutta tribunal also. It affects Calcutta. I may be posted at Calcutta.
Entire selection process was conducted in Delhi.
But the part cause of action.
How?
Because ultimately it affects the appointment in the Calcutta Claim Tribunal also. I may be posted there, may not be. But ultimately, this entire notification, if it considers, there is very implications in the notification itself. It has been addressed to the, notified to the all the register, including the Calcutta High Court Registrar General.
First of all, there is a question relating to jurisdiction of this court.
In that case,
second of all, this the second aspect is this, that on 27th of June 2024, final list was published containing names of 16 candidates. Your name was not there and all have been appointed.
Yeah, but-
What remains?
My lord, so for the merit is concerned, I am answering letter.
Issue.
No, my lord, kindly give me 1 minute time, my lord. I will-
Yes.
My lord, kindly. I have come up with the judgments on whatever lordships have pointed out. If your lordship allow me, I will place 3 judgments in seriatim. That judgment will show that the convenience of the litigant will be looked into. If the
No, I am not on only on cause of action, territorial jurisdiction. I am also on the facts of the case that after the selection process was complete and appointments are made in terms of a document at page 31. What remains?
That is nowhere answered. The appointment is made. How far back?
So I am not on territorial jurisdiction. I will decide on the facts also.
Yes, your lordship, kindly, my lord, then kindly come to the page number, my lord. I am just coming to the selection procedure. Apparently, on the face of it, there is some arbitrary action. Kindly come to page 27. It starts the first list. And first list, before first list was published, I was interviewed. My IB report, my personal data, all was gathered.
Search and selection committee has not been made party. Who has
in the advertisement? There is no mention about any permanent address. It is a 4 years terms appointment. It is a contractual appointment. So
it depends upon IB report. So therefore, court will not enter into this.
My IB report is not negatived by anybody. Nobody said that you are negative in the IB report. Police verification made, interview made. Then, my lord, kindly come. Why I am saying it arbitrary? Page number 27 is the first shortlist, and my name is appearing out of 71 selected candidates. Shobhan Siddhanto, advocate, page 29, as item number 47 among the top of all advocates list. Serial number is thereafter all other advocates. So thereafter second list came in 2024. I do not know whether the entire, so far my information, the entire post may not be fulfilled. In this selection list, the advocates who have been
matter is heard in presence of the learned advocates representing the petitioner, and you are appearing Union of India Railway
Union and Railway both.
And the respondents. Stop. Next paragraph. Matter centers around appointment as judicial member in Railway Claims Tribunal within bracket for short RCT. Stop. RCT. Stop. It is contended on behalf of the petitioner that based on a vacancy circular dated 18 September 2021, petitioner applied for being appointed as judicial member in RCT, and he was enlisted along with 70 other candidates. Stop. Subsequently, petitioner was not shortlisted. When a list of 32 candidates on scrutiny and screening was published, this publication was made by that selection committee, search and selection committee,
everything.
Published by Search and Selection Committee. Stop. Petitioner questions preparation of shortlist on 27 June 2024, and it is submitted that petitioner's name ought to have featured in the said list dated 27 June 2024. Stop. According to the petitioner assessment of candidates who applied for judicial member in RCT was improper, resulting in exclusion of name of the petitioner from the list dated 27 June 2024, denying his right to be considered for appointment. Stop. Next paragraph. During course of hearing, point of territorial jurisdiction is raised on behalf of the respondent authorities, and same is answered by the learned advocate representing the petitioner based on vacancy circular dated 18 September 2021. And it is contended that though the selection process was conducted by the authorities who are not within whose offices are not within territorial jurisdiction of this court, but Kolkata was one of the places where, as per vacancy circular dated 18 September 2021, judicial member was scheduled to be appointed in RCT. As RCT, stop. Based on such vacancy circular dated 18 September 2021, it is contended part cause of action arose within the territorial jurisdiction of this court. Next paragraph, Mr. Dhiraj Trivedi, learned senior advocate representing Mr. Dhiraj Trivedi, learned Deputy Solicitor General, appears on behalf of respondents who has opposed this petition first on the point of territorial jurisdiction, as all the respondent authorities, as the offices of all the respondent authorities situate outside the jurisdiction of this court, and selection process was conducted not within the jurisdiction, not within the territorial jurisdiction of this court. Stop. Next paragraph. In addition thereto, it is also submitted, if facts are looked, if the issue involved in this, writ petition is looked into apart from jurisdictional point, then this writ petition does not merit consideration, since short list was prepared on 27 June 2024, where petitioner's name did not feature. Stop. Initially, petitioner's name appeared along with appeared in the list dated 27 June 2024. 27 June 2024, and in the same day, two lists were prepared.
My lord,
same date.
My lord, it is appearing at the bottom. From the bar, I cannot make such submissions, my lord, because I am not aware. They have also, being writ petitioners, they are knowing it. They have not come up with any statement regarding that. But then, my lord, whatever remains, we are on one page on this, that anything happened, they had knowledge in the month of June. I am on knowledge. He has the carriage of proceedings. He had knowledge in the month of June, which he is championing for.
They did not communicate anything.
Why should we communicate, my lord?
Kindly
appreciate.
I've got it from website.
Now, since petitioner was not shortlisted candidate, and though petitioner's name featured in the list of 71 candidates initially. In the initial list of 71 candidates, stop. Based on shortlist, which is at page 30 of the based on shortlist, the final list was prepared containing names of 16 candidates, and all the 16 candidates were given appointment. Mr. Trivedi, whether all the 16 candidates were given appointment?
My lord, my instructions, if my lord kindly takes up. If my lord kindly takes up 3.4. Before that, my lord, may I read? 3.3, that is keeping in view of the Tribunal Reforms Act 2021, the Tribunal, the SSC, through personal interaction after taking into account the suitability, record of past performances, integrity, as well as the adjudicatory experience, keeping in view the requirement of tribunal, recommended 32 candidates only against 16 for judicial post. Now, then, my lord, the committee has held a meeting on 7/2/2023 and decided to exclude 16 recommended candidates from the earlier panel of 32 in view of adverse feedback, and against 4 candidates, the finally 28 were candidates were selected. Now, Lordship, this is clear.
4 is vacant. 4 is still vacant. 4 post is still vacant.
28 candidates.
28 candidates, because on IB report, then, my lord, we have specifically stated, my lord, we have specifically stated, my lord, that he did not even figure out in 32 candidates. That is at paragraph 3.5.
Then this, what about this document at page 30?
My lord, they must have got it from the computer. The date of printout is there, my lord.
My lord, I have
the date of printout is there, my lord. My instruction is
then it has to be on record.
Yes.
File a affidavit.
That is why I.
My lord, I shall file an affidavit.
Is obscured.
My lord, I shall file an affidavit. I apologize, my lord. My lord,
there are 4 posts.
My lord, judicial. Because, my lord, what he is submitting, when you take a printout, my lord.
ওটাকে না একটা তুমি ড্রাফট অর্ডার হিসেবে করে রাখবে, পরে যখন করবো ওটা দেখবো তুমি yes record a different order. Matter is heard in presence of the learned advocates representing the petitioner and Mr. Trivedi, Deputy Solicitor General, representing respondent. Stop. It is submitted on behalf of respondents that selection process for the post of judicial member in Railway Claims Tribunal is complete by giving appointment to the selected candidates, and petitioner was not selected for the said post based on IB reports. Based on IB report,
their instructions are there.
Stop. In addition thereto, it is also submitted that selection process was conducted by search and selection committee within bracket SCSC close bracket, and said search and selection committee has not been made party. It is also submitted that this court does not have territorial jurisdiction to entertain this writ petition. Next paragraph. Concerned respondent authority is directed to file a report in the form of affidavit disclosing.
My lord will kindly record that we have filed an instruction, but my lord directs me to file
disclosing the details relating to the steps taken by the selection authority for filling up the post of judicial member in RCT, and when the panel expired. Stop.
When the Lordship, we have to say when the selection process was completed and when the panel expired. My lord will kindly say. And my lord will kindly record that we have given it.
Next paragraph. 10 days bollam, tai to? List the matter under the same heading for further consideration on 15 December 2025.
15 December, my lord will be too less. My lord will give me 1 more week.
22nd December 2025. Stop. Stop.
my
Next
instruction had
paragraph, the documents filed today on behalf of respondent authorities are taken on record.
If it be granted to me, my lord, to give a reply. If it be granted to me to give a reply.
exception he is.
No, not at this stage. Let me see.
And my main consideration that what
তাহলে তো
criteria,
next year হয়ে
criteria
যাবে।
they have considered. That is totally obscure.
Yes, yes.
Yes.
I'm grateful, my lord.
Item number 16.
I'm appealing for the Public Service Commission.
To regarding the petitioner participated in selection and recruitment to the post of the supervisor. Petitioner or
Yes,
the
yes.
post of the supervisor of ICDS. Or the petitioner all of the ICDS worker.
So whether these appointments are made through Public Service Commission,
Lordship.
supervisor in ICDS.
Yes, Lordship. There are two recruitment process, direct recruitment and by promotion. For the direct recruitment, Public Service Commission published the advertisement, and for the promotion, the department itself published the advertisement, and they received the form and they forward to us. And for the both examination, recommendation list has been forwarded.
Whether the petitioners applied for promotion or fresh recruitment. Promotion. Yes.
Or the issue is whether the vacancies be fill up in 50-50 ratio or 75-25 ratio. 50-50 ratio. Total vacancy 55% from the promotional and 50% from the direct recruitment. This is the central government notification. But the state governments, by violating that notification, they are going to fill up in 75 from the direct recruitment, 25 from
75 is to 25.
Yes.
So that is in violation of the central government
notification at 2015. The petition was moved before this honorable court, my lord. Justice Lopita Banerjee was pleased to direct the post should be filled up by considering the notification of the central government in 50-50 ratio. The state government prefer an appeal. The division bench in our High Court was affirmed the order of the single bench and directed the post should be filled up in 50-50 ratio. Thereafter, the state government prefer an SLP before the Supreme Court. The SLP is pending, the SLP admitted, and issue is pending for only that part. So whether the post will be fill up in 50-50 ratio or 75. That's why I'm praying adjournment for 2 weeks because that time result will be come.
Matter is scheduled to come on a particular.
15th
So
December.
this determination of vacancies is solely the responsibility of the department concerned.
Another
Just
4 or 5 SLPs are also pending, my lord.
Whether the appointments are made based on
Lordship, we have sent the recommendation for the direct recruitment. The recommendation was sent on 3rd February 2023, and for the promotion through selection recommendation was sent on 12th April
you are appealing for the
2024.
West Bengal Public Service Commission.
Yes,
For the
Lordship.
state government.
I'm for the state.
Whether the appointments are made.
Mr. Ghalib, my lord,
Whether the appointments are made.
that I am not aware, my lord.
You are not an impaneled state impaneled member. So why you are not aware?
My lord, the engagement was made by the ILAG, my lord. Another state of admin.
You are not appearing in this matter. So then why you are not aware?
I am engaged by GP, my lord, Lieutenant GP.
So that's why for
Later-
those who are engaged by GP, they are not entitled to know the facts of the case.
My lord, let's
They are the appointing authority, so it will be within their
State
knowledge.
appointing authority
Yes,
based
sir.
on the recommendation made by the
Yes,
Public
yes.
Service Commission.
It has been made long time back.
Last memo has been issued on 14th October 2025 that there's some candidate might have given appointment in the during the pendency of this the SLP.
So let the matter go out of list since the issue is pending before the Supreme Court on the identical issue,
Lordship.
on the identical point.
Lordship.
Issue. Issue involved in this writ petition is whether posts are to be filled up based on 50-50 ratio thereby giving opportunity for promotion as well as fresh candidates to be recruited directly, or at the ratio of 25:75. Next paragraph. During course of hearing, the next paragraph koro. West Bengal Public Service Commission and state respondents are represented by learned advocates. Next paragraph. During course of hearing, an order dated 2nd September 2025 passed by the Honorable Supreme Court on special leave petition within bracket civil close bracket diary number 40529/2025 arising out of judgment and order dated 24 January 2025 passed in intracourt appeal being MAT 493/2024 and 24 January 2025. Now, and judgment and order dated 24 January 2025 passed in another intercourt appeal being MAT 509 of 2024 within bracket state of West Bengal versus Papia, Ghoshal, Maiti and others close bracket is pending. সেন্টেন্সটা কিভাবে শুরু করেছিলাম? Respondent represented. In so and so and so. না, is pending টা কেটে দাও। Dated 2nd September 2025 is placed before this court and same is taken on record. Stop. On perusal of the said order dated 2nd September 2025, it appears that similar issue is pending before the Honorable Supreme Court. Next paragraph. Let this writ petition go out of list with liberty to mention after after
Can it be recorded that we have already published the recommendation list?
Not required at this stage. If ultimately SLP is allowed, then your recommendation will go. There is no use of recording this. Yes, item number? Out of turn, I will not take up this. Yes. Documents and affidavit of service deficit court fee. Next.
Grateful, my lord.
Item number 17.
For the petition amendment. Per your lordship directions, my lord, copy has been stuck upon the date of West Bengal and one of the respondents as directed, my lord, and both the parties received, but I could not able to. But today,
Yes.
State appear করেছে?
Yes, yes, state
okay.
no, state no. I mean, private respondent number 4, your lordships. Private respondent number 4.
Yes.
Yes, I am appearing on private.
Yes, yes. What is the matter about?
Matter about my lord.
You are appearing for Mr. Mukherjee?
But I am for the district judge Barwan, Paschim Bardhan.
Yes.
Matter. Matter regarding my lord, pension and fight in between two wives.
Yes.
Fight in between two wives who will get pension with the department concerned. And there are, prior to that, legal proceedings was.
Have you served upon respondent number 4?
Yes, yes, I am appearing on respondent private respondent.
Another wife?
Another one.
Yes. First wife.
Yes.
Now, my lord, there are a number of litigation previously.
Employee died.
Employee died.
Employee was in receipt of pension.
No.
Died in harness.
During the service period.
Yes.
Thereafter, claim between the two wives lodged before the concerned authorities concerned.
So if you are the second wife, where is your right?
Prior to that, the present petitioner has lodged number of civil litigation and criminal litigation against that his husband, against her husband, before the different court, wherein she resides and the husband resides, and it was go up to the Supreme Court also, and also the High Court, and thereafter Supreme Court. In each and every court, the petitioner has able to succeed. Declares that he is the wife, she is the wife, but the when the department concerned has initiated an inquiry proceedings under the guise of the department inquiry, inquiry initiated by my lord, as per the list of dates, my lords. Yes. I am handing over the list of dates, my lord. And the
The inquiry committee was constituted by whom?
by the district judge, my lord.
What happened normally, if this situation arises, if the person is employed in the particular concerned district, the district judge used to constitute a committee headed by a additional district in the rank of additional district judge along with two other judges, judicial officer. This has been done, and ultimately, my lord, all the documents filed by both the parties on 14/8/2024, but the order has been passed, which has been challenged before your lordship by this writ petition.
Where is such report? Where is said report? 14th August.
Annex, my lord, kindly see
Page.
order page 45.
Page 45 onwards, my lord. Long order, my lord. There are 6 pages order.
But if your lordship see,
Pages order, there are number.
if your lordship see, my lord, from the official document, this is the, my lord, recording.
But official documents is not at all.
Page?
My internal page 3, we find from the
Page
copy
50.
Page 48.
Where is the relevant part of this report?
order.
Order.
Well, come at 2.
Continue item number 17.
Yes, my lord. My lord, can you see the impugned
Yes, I was considering the inquiry report, just a minute.
page 45 onwards, my lord? Probably 17 documents has been referred, but not considered.
Wait.
Page, my lord.
Wait. So the committee, after consideration of registration certificate and nomination, has decided
Yes, my lord.
that respondent number 5 is the legally
This
married
legal heirs
wife
of the deceased
of the
employee.
deceased employee. Yes.
But that is their observation of the inquiry committee regarding that nomination.
Where is the
But
wrong of in that
nomination-
observation?
Nomination does not, as per the Hindu Succession Act, my lord.
Where is
Nomination-
that? But registration certificate?
Registration certificate, that registration certificate actually manufactured, not original. This was manufactured and not even the copy of the marriage certificate.
Birth certificate of children?
That is not the criteria. We are not on that fact. Only the marriage is.
And the deceased employee during his tenure, got a health card, their service records and notes in the service book of deceased Taraknath Kaur indicates that Chandana Kaur is the legally married wife, and her name has been mentioned in the nominee, as also her name is recorded in the West Bengal Health Scheme 2008. That means the employee himself recorded the name of the first wife.
Employee recorded, or the government itself on the basis of the submission.
No. Nomination has to be exercised by the employee. And the employee exercised nomination, including name of the respondent number 5.
Assuming for a moment that the employee recorded the name of this wife as a nominee and also in the health scheme also.
So what are the documents you are relying upon to substantiate your case that you are the wife of the deceased employee?
We have placed different 17 documents relating to the yes. This is the latest, but earlier suit which was contested in between the husbands and the petitioner, wherein petitioner admitted before this honorable High Court that Lipika Datto is my wife by petition and by averments.
Where is the order of this court?
And
Honorable High
that
Court?
order was also annexed and placed before this
Declaring that the
yes,
respondent petitioner is the wife.
Yes, my lord.
Yes. Show me.
There are a number of documents, my lord.
Please show me that this court has declared the petitioner as the legally married wife of the employee. Show me.
There are number of judgments, my lord.
Please show me that this court has declared petitioner as legally married wife.
Yeah, I am.
Judgments will come later. Please show me.
That judgment particularly.
I am asking you, please show me.
I
Please show me the order of this court declaring the petitioner as the legally married wife of the employee.
All the judgment heaps of papers, my lord. I am kept it in my chamber, my lord. It will take tomorrow, my lord.
So
number of judgment, my lord. I am please pass over me half an hour. I am bringing, my lord, all the judgment, not only the Supreme Court judgment, my lord. I am placing before your lordship. Kindly.
Where are those orders? Matter is continuing. There is a recess break, and you are not in a position to bring these judgments.
I was ill since the last 10 days, my lord. Therefore, I could not bring all these papers, my lord. Kindly half an hour's time, my clerk will bring.
Not today. Not today. Come back today.
Can it be on Monday?
No, I have heard this matter. Sorry.
Instead of tomorrow, only tomorrow I have, my lord, 10:30 matter has been fixed for my lord, Justice Bhattacharya, because I want to.
Not today and tomorrow, Wednesday.
I will bring all the with
Next
final
matter.
binding.
Item number 18.
My lord, 18, I am for the petitioner, my lord.
My lord, I appear for the Digha Shankarpur Development Authority.
My lord, I am for the state.
My lord, the lordship on the last occasion.
Just a minute.
I'm sorry. बोलो दो কি করবে মামলা তুই করবি গুড ভেরি গুড ব্রিফ কোথায় তোর উপরে রাখ গুড খুলে রাখ
Yes.
But on the last occasion, Lordship had directed the Digha Shankarpur Development Authority to file a short report. But may I file that? But I've served it upon my learned friend on 24th of November.
Yes.
My lord, on this report, I want to file an exception.
Let me see what is there. Which paragraph you are relying upon, Mr. Bihani?
Very short paragraph. Kindly see paragraph 3 onward. I'll make it short. Well,
Just a minute.
I'm sorry.
Short na shorter.
Shortest. Go straight. ডকুমেন্টটা দেখাতো কোথাও নিজে ছেড়ে গেছে দেওয়া গেছে নিজে চলে গেছে কোথায় ছিল এখন ফাইল হয়েছে একটা কিছু করার নেই। এইটা হচ্ছে আগের লিস্ট বুঝতে পেরেছিস এটা কি করেছিল কি জন্য করেছিল কি জন্য করেছিল ও নিজে ম্যানেজ করেছে
Where a master role employee worked on a casual basis and worked from 2003 to 2022. Thereafter, this maintenance work, electrical maintenance work was handed over to the PWD. What is PWDT?
Directorate.
Yes?
Directorate.
Oh, PWD department. So where is your right? If your appointment was on casual basis, not on substantive appointment, and it is already that work is carried out by PWD, where is your right? Praying for continuity in service. Even not even the appointment letter is annexed to this writ petition.
And for that only I want to file this
No, you have to demonstrate. It's no use of filing the further affidavit because in their writ petition also the appointment letter is not there.
Yeah, I have taken instruction from my client that he can provide me with the appointment letter.
So why this has not been annexed to this writ petition?
And at that time, at that point.
So, sorry. In terms of the order dated 6 November 2025, a report is filed in the form of affidavit affirmed on 21st November 2025 by the Special Revenue Officer 2, Capital Roman 2 of Digha Shankarpur Development Authority, and same is taken on record. Stop. On perusal of the report, it transpires that petitioner worked from 2003 to April 11th April 2022 intermittently as per requirement as daily rated master role worker in connection with electrical maintenance. Stop. It is also stated that it is also averred that petitioner worked for the petitioner's last date when petitioner worked was 11th April 2022. Stop. Thereafter, electrical maintenance work was or is carried out by PWD department by PWD by Public Works Department from August 2024. Next paragraph. Petitioner claims continuity in service by regularizing his appointment. Stop. In the writ petition, no appointment letter is annexed. And in the report filed today, it is disclosed that petitioners work on daily rated basis, intermittently, as per requirement of the concerned respondent authority. Stop. Considering the nature of engagement of the petitioner, it appears no right accrues in favor of the petitioner, warranting issuance of mandamus in order to protect such right relating to continuity in service. In this regard, reliance is placed on the judgment of the Honorable Supreme Court reported in 2006, Volume 4, 1 SCC. Uma Devi. Next paragraph, no relief can be granted to the petitioner. Writ petition stands dismissed. Next.
Item number 19.
My lord, I am for the respondent.
Yes.
My senior could not come because she is having some personal difficulties. The report has been made. It's just yet to be affirmed. So kindly grant me a short accommodation for 2 to 3 days for compliance.
What has happened to your senior?
No, she has some personal difficulty in her family.
Tomorrow she will not come.
Tomorrow is she has other matters too. Maybe on Wednesday or Friday it would be suffice.
Come back.
She plus to tell me in the morning.
At the time of call, accommodation is prayed for on behalf of respondent authorities on the personal ground of the learned advocate. However, petitioner is represented by learned advocate. Stop. Hearing of this matter stands adjourned till 4th December 2025. You could have communicated it to the learned advocate.
I did not know him, sir, actually.
Item number 20.
I am for the petitioner, my lord. Praying for an adjournment for this week.
Yes.
Praying for an adjournment for this week.
Why?
Advocate on record has fallen sick, my lord. Sick of fever and huge back pain, my lord.
I directed to produce the copy of the writ petition 14868 of 2016.
Whether as to
Do you have the copy of the writ petition? Why not the department, Union of India, and the concerned respondent authorities were party?
Yes, but
the border security force.
I find from the copy provided by the petitioner that he has not enclosed the.
So you produce this 14868 in order to find out whether there is a
Whether he had made the prayer with regard to the back wages.
Petition relating to back wages.
Back wages. Whether he had, whether in the previous writ application.
So
he
you
had
also
made
try to find out.
I will, my lord.
Because BSA was party.
BSA was
Previously, it was a termination order which was under challenge. And matter went up to the Honorable Division Bench. Challenge failed. Petitioner was reinstated.
The
now
division
petitioner
bench
claims back wages.
Division bench did not set aside the order passed by the. It was upheld.
Yes,
but
I have
with an
recorded.
Observation
I have
that-
recorded in my order dated 6 November 2025. But court, considering the issue involved, finds it apt to direct to give direction for production of the previous.
The division
writ
bench
petition.
had made a remark that we may not be may not be completely inclined towards the observations made by the learned single judge, but however
Order was not interfered with.
order was not interfered.
So you try to produce this.
The previous writ application.
It may so happen that this on the next date also prayer is made for
No,
accommodation.
I will ensure to get the copy.
The court does not want to drag this matter.
No, my lord,
further.
this can be disposed of.
Yes, but based on the prayer which is before that, court needs to consider the prayer which was made in the previous week.
My lord, the issue is only with regard to this 2598 days of extraordinary leave. Now, whether he is entitled to
That
full
was
validity-
a charge.
That
that court will not enter into because it has already been decided by the coordinate. Now the question is this, whether he is entitled to get.
He has been reinstated.
But issue was leave.
Whether he is entitled to payment with regard to 2598 days extraordinary leave during that period. That is Lordship will decide. I have got
The
a couple
charge
of,
was taking unauthorized leave.
he is only claiming for those with regard to the other
That was
periods.
the only charge.
With regard to all the periods, he has been promoted, he has been given at par.
Only that's 256.
That 2598, 2598 days of extraordinary leave for which he has not been paid. This is the issue. So whether he should be,
So that was the only charge based on which disciplinary proceeding was initiated against the
that
petitioner.
was because of color blindness. That a person who has been suffering from color blindness cannot render
Act as
service
an,
with the BSF.
cannot work in BSF.
Cannot work in
discipline
BSF.
force.
So consistently the findings of the BSF went against him. Eventually he came up before this court. This court found that he
So
can.
this was not a charge. Unauthorized leave was not a charge.
No. That was not the charge. The charge was of color blindness. That a person who is suffering from color blindness cannot serve in the BSF.
So he took leave during the period when petitioner was, when the order of termination was
After
issued.
termination, this leave period is after termination.
So then in that event, if after termination petitioner was not allowed to join duty,
naturally,
then subsequently petitioner was reinstated. So why petitioner will not get the salary?
My lord, I will let the writ application come up before your lordship with the previous writ application.
I could understand that unauthorized leave was one of the charges framed against the petitioner. That is not the charge. Now you terminated the petitioner. That termination order was under challenge. Matter was pending before this court. Ultimately, court decided in favor of the petitioner, which was not interfered with by the Honorable Division Bench. But due to termination order, petitioner could not discharge duty. Why petitioner will not get that service benefit?
My lord, there are number of.
It is not a case relating to
I bow down before
back
your lordship,
wages
what is falling from
prior
your
to issuance of termination order.
The single bench came to a finding that he may be given to non-emergency works or certain other works which may not be affected due to his color blindness.
Yes.
My lord, the period of work in BSF was very limited. Now, my lord, there are a couple of decisions of the Honorable Apex Court which says that from case to case, it would vary. It is to be taken into consideration how much period he has worked, what service he has rendered, all these things, whether it would be 25% or 50% or 75% or with full back wages. So that depends on case to case. I will give a couple of judgments, lordship will take up on the next occasion when I get the copy of the other. Let my learned friend bring it as well. I will also try to get it.
What, but 25% of what? 50%?
Back wages.
No, back wages relates to the date of suspension or date of initiation of proceedings till the date of issuance of or date of reinstatement of the petitioner.
I just came across one judgment of the Honorable Apex Court in which the person could
But
not.
here petitioner claims wages after termination order was set aside.
Bow down before your lordship. I absolutely, there is no dispute with regard to
back wages for which period is considered in most of the matters. You will find that suppose in contemplation of disciplinary proceeding, a person is suspended or not paid salary. Ultimately, petitioner is reinstated after 5 years, say. So during this period of continuation of disciplinary proceedings and prior to reinstatement, if a considerable time has passed away, then whether petitioner is entitled to get the salary for this period when proceeding was continuing. Here is a case where petitioner was directed to be reinstated, but that reinstatement was not carried out by your department. Now, if that is so, why petitioner will not get arrear salary, back wages?
Passed, my lord, he preferred an appeal, but that was carried out, and that has also been recorded by the division bench on contempt. That has been recorded by the division bench.
So appeal was preferred by the petitioner.
Appeal was preferred by the authority.
Yes.
BSF.
So then why petitioner will be penalized for that? Had the order of the coordinate bench would have been implemented on the next date, then question of back wages would not arise.
In between, quite a number of years had passed.
For whom? Who is attributable to that?
That is BSF authorities. It was
Yes.
pending before the BSF authorities, then before the Honorable Single Judge.
I am under the impression that during continuation of proceeding, petitioner was not allowed to discharge duty. And then question of back wages come. In many cases, Supreme Court has also directed 50% back wages.
My lord.
But after the issue is decided by this court, when petitioner was not permitted to discharge this duty, that the fault is not attributable to the petitioner.
Then Lordship can also direct that back wages from the date of reinstatement passed by the Honorable Single Judge.
Yes.
That can also be done. That can
So that does not cover 2000 and odd days.
No.
A part is prior that is prior to
much prior to that. Much prior to that. A small list of dates I will place before your Lordship, so that Lordship can come to the finding that as with regard to what has happened when. Because he joined.
So at least from the date of passing order, you release salary.
My lord, he joined BSF on this particular commandment on 9th June 14. He joined in the services.
On reinstatement?
No. Initially.
My
lord, he was recruited on 20th July 2012. He was enrolled in BSF on
initially recruited 8
initial
April 2013, appointed on 8 April 2013.
Initial recruitment 2012, July 2012, enrolled in BSF in April 2013 and joined BSF on 9th June 2014. This date is extremely pertinent.
9 June 2014 joined.
My lord, he was removed from service on 10th August 2015.
Removed or terminated or dismissal?
Terminated.
Dismissal or removal?
Probably dismissal from service, terminated. That is 10th August 2015. 10th August 2015.
Yes.
Now
This was challenged.
And eventually reinstated in service pursuant to the.
When the order was passed by the coordinate bench allowing this writ petition. Yes, 5th July 2017.
5th July 2017. And he is reinstated in service on 29th December 2022.
Then the order of the division bench, 30th June 2022.
30th June 2022. And reinstated in service on 29th December 2022.
15 December 2022. Page 128 of the writ petition.
Well, I find that he was reinstated on 29th December 2022. I will just check once.
29 December. Order is dated 15 December. But
order is dated
15 December.
This date I will have to check once.
But reinstated, joined on 29 December 2022. Now you are reckoning this period from which date? These 2000 and odd days?
From the date of termination. Since from that day he was not in service. So that is the computation which the BSF has forwarded. Page 133, Lordship may kindly take up. A detailed breakup has been given.
But from the date of removal, if the removal order goes, you have to pay salary. Sorry.
This is with regard to extraordinary.
I was under the impression that during continuation he was not paid. Continuation of disciplinary proceedings. But when removal order does not survive by the dint of the order of the coordinate bench, and the division bench also did not interfere with the order of the coordinate bench, then he is entitled to get the salary from the date of removal. Because your very order of removal goes.
My lord, the apex court, I was just going through a couple of decisions. The apex court says salary does not mean that you will be entitled to the entire relief which you would have been entitled had you worked there. Well,
but at whose instance he could not work?
It is true that but Lordship kindly appreciates the medical board has consistently found that he was not in a
chapter,
position.
Mr. Dev, is over.
All right. That is
That chapter court will cannot reopen in this matter. Whether what was the report, medical report based on which way your removal order was right or wrong. That chapter is over. It's a closed chapter. Question is on petitioner was removed on 10th August 2015 and this order did not survive. So if this is the position, then from the date of removal, at least petitioner is entitled to get the salary.
Removal from service was on 10th August 2015.
Yes, 2015 till the date of joining. After joining reinstatement, he is getting till 28 December 2022. Petitioner is entitled to get the benefits.
Lordship, kindly takes it up on next. Let me get the copy of the other.
Dispose it of.
No, Lordship can kindly keeps it on one.
Nothing
more day.
remains.
Because, my lord, let me get the.
It was in my mind that during the period of the proceeding, he was not allowed to work. As a result whereof he is claiming salary.
No.
That is not the issue.
He was terminated because of color
The
blindness.
very basis of your non-payment of salary is removal. Now the removal goes by dint of the order, and you prefer an appeal. This appeal was this order of the coordinate bench was on 5th July 2017. Appeal was disposed of on 30th June 2022. He is entitled to get the entire benefits. Petitioner.
He was reinstated on 29th December 2022. Pursuant
By
to the
preferring an appeal, you cannot be benefited in such way when the appeal was dismissed.
Lordship can always grant him the remedy from the date of the order passed by the learned single judge.
No, it is a case of order by the quasi-judicial authority, disciplinary authority. So, therefore, time starts ticking from the date of order passed by the quasi-judicial authority.
I bowed out before your lordship, but kindly takes it up. Let me place a couple of judgments.
Yes.
We'll refer to the judgments and pass necessary orders.
Matter is heard in presence of the learned. At the time of call, accommodation is prayed for on behalf of the petitioner. On the personal ground of the learned advocate. However, Mr. Debojyoti Dev, learned advocate representing Union of India, has made submissions and matter is heard to some length. Next paragraph. Hearing of this matter stands adjourned. Stop list. এটা কি combined list থাকছে? Combined list stands. Hearing of this matter stands adjourned till you are praying for accommodation for how many days?
1 week.
1 week. What has happened to the advocate?
She has fallen sick of fever and a huge back pain also.
Hearing of this matter stands adjourned till 10 December 2025.
Grateful, Minute. Grateful.
Item number 21.
In this matter, I am appearing for the petitioner. In compliance with your lordship's direction, I have served upon all the respondents, including Mr. Ghalib, my lord, who is appearing on behalf of the state, my lord. My lord, this is similar matter, my lord, item number 16, my lord, regarding the appointment, direct recruitment supervisor in the post ICDS.
But in absence of other side, how I can take up this matter?
Yes, my lord. Similar order may be passed, my lord. 16th Supreme Court is pending. I was here, my lord. Direct 50% appointment direct and 50% promotion. I am the promotional candidate. My lord, in the meantime, I have been informed that some appointment is being made from the direct recruitment, my lord. That is why the petitioner may file an supplementary affidavit.
How you have served upon the state?
Yes, my lord.
How you have served upon the state?
Mr. Ghalib, my lord, I have served. And public service.
Where is Mr. Ghalib? And Olok Banerjee.
Yes, my both.
Not today, come back tomorrow, inform them. That 25% and 75%.
Yes, my lord.
Very well, not today, come back, inform them. Otherwise, I will engage some other advocate from the state panel. Not today.
Item number 22.
I am for the petitioner. Can you see the last order, Your Lordship?
Yes.
Listen.
Yes. Where is the scheme? Where is the scheme? Point number 16. Yes. Point number 16, page 6. Clause 16. Yes. What is the name of the scheme? Employment assistance to the dependents of the deceased government servants who died. Employment assistance to the dependents of deceased government servants. It is 11th February 2020 scheme. Yes. 11th February 2020. Which clause you are referring? Clause 16. Page 6 of restricted document report.
Take retrospective, it's a perspective. The fact that the perspective, not perspective. যদি বলো later past 3 years
Now, clause 16, please place clause 16. As per new guidelines.
As per the new guidelines contained in the left poem number this much, dated 30th April 2015, any application for compassionate appointment is to be considered without any time limit and decision taken on merit in each case. Hence, in case of not recommended candidates, the outcome of the board will be communicated to each applicant after completion of board. We then advise to the applicant to apply fresh application for consideration in next board.
Where is such communication? Where is such communication?
The communication was given to.
Show me that this communication was made to the petitioner with a request to apply afresh. Any communication was made
This communication was
to you
Lordship,
as per clause 16.
Lordship, kindly see last page. My application was sent.
Last page.
Last page. Page 33. Is their communication.
When you made an application for
2019.
no monetary benefits were paid.
No, monetary benefit has been given.
Lord, page 24.
That is relating to non-receipt of documents by the concerned authority for payment of monetary benefits. Now, I am asking you in reference to clause 16. Come back to clause 16 again. As the new guidelines contained in so-and-so dated 30th April 2015, any application for compassionate appointment is to be considered without any time limit and decision taken on merit in each case. Hence, in case of non-recommended candidates, the outcome of the board will be communicated to each applicant after completion of board with an advice to the applicant to apply a fresh application for consideration in the next board. So it is provided herein that hence in the case of non-recommended candidates, outcome of the board will be communicated to each applicant after completion of board with an advice to the applicant to apply afresh. Where is such communication?
Page 24. Page 24.
Page 24.
30 June 2021.
Of the writ petition.
Was intimated to the petitioner.
Third paragraph.
Yes, there was a communication in 2021. Why you did not apply? Because paragraph 3 says you are at liberty to apply afresh as per rules in force existing provisions for the consideration of the next board, tentatively scheduled to be held on April 2022. Why you have not applied?
Madam, I made an application 2019.
No, but
The scheme-
subsequently, as
scheme
per
was-
scheme, it is required.
was
Each year,
2020.
if your application could not be considered, your application was considered. You were placed at serial number 34, where there were 22 vacancies. So therefore, you did not come within the zone of consideration. So for which, as per scheme, they communicated you are at liberty to apply afresh as per rules in force existing provisions for consideration in the next board. So why you did not apply?
With my impression that my application will.
Your impression will not help you.
Application, I made an application 2019. They should comment. They immediately they should communicate it. But in 2020,
This was exercise was made by the authority, but subsequently you did not apply. From 2021 communication, you sat tight over the issue.
let them liberty may be given to make an application.
Let an application be made afresh because there is no time limit, and let it be considered in the next board of officers. Next board of officers.
But there is limitation of 5% quota reserve. That's the main problem.
Yes, 5% it is
That's why
there. I
it
have
is-
seen that against 5% quota reserved for compensation. That's why 22 vacancies were there, 22 posts were there, which could have been considered for appointment on compensation ground. Petitioner's serial number was 34. As a result, however, petitioner did not come within the zone of consideration. With the request, it was communicated with the request to apply afresh in terms of clause 16, but that was not done. So now I will direct the authority petitioner to make a fresh application.
If they will make fresh application, we will make
And
a-
that will be considered because your rule says there is no time limit.
Yes. Previously,
says
it was
that
time
in
limit,
case-
but it has now been improved.
Yes,
Previously, it was time limit for 3 years.
but now there is no time limit.
So
In case of recommended candidate, board proceedings and
petitioner can apply.
as per- any application for compensation appointment is to be considered without any time limit. So therefore, let the petitioner apply afresh as per communication dated 30th June 2021. Inadvertently, petitioner could not apply, and let it be considered by the board of officers in the next exercise issue. Husband died in harness. He was working where? BSF.
Indian Army. Indian Army.
Indian
Army.
Indian Army.
Paragraph 4.
Matter is heard in presence of the learned advocates representing the petitioner and respondents. So, next paragraph, as per order dated 6 November 2025. Scheme of appointment on compassionate ground, that is employment assistance to the dependents of deceased government servants who die in harness or retire on medical grounds. এই দেখো এইখানটা পাবে। Dated 11th February 2020 is placed before this court for consideration. Stopped. On perusal, next paragraph, on perusal of said scheme. আচ্ছা এইখানে ওই যে দ্যাট ইজ বলে যে নোমেনক্লেচারটা বললাম তার পাশে হিয়ারিং আপনার রেফার টু এজ দ্য সেড স্কিম ক্লোজ ব্র্যাকেট next paragraph on perusal of the said scheme it appears in order to adjudicate the issue involved in this writ petition clause 16 is relevant which is quoted below clause 16 টা এখানে পাবে এটাকে কোট করে দেবে As per clause 16, an application for compassionate appointment can be made before the concerned respondent authority, and there is no time limit fixed for submitting such application, and decision relating to right of the applicant to be appointed on compassionate ground is to be taken on case-to-case basis. Stop. It is further provided in clause 16. In the event an applicant is not recommended, the result, the decision of board of officers is communicated to the applicant with an advice to the applicant to apply afresh, or with an advice to the applicant to apply afresh for appointment on compassionate ground. Next paragraph. In the present case, husband of the petitioner was serving in Indian Army and died in harness on 6 November 2018. Stop. Subsequent thereto, petitioner applied for appointment on compassionate ground, which was considered by board of officers, BO দুটোই সব জায়গায় capital, board of officers in 2020, and a panel was prepared where petitioner's name featured at serial number 34. Stop. As per norms, 5% of now, as per norms, 5% vacancies are reserved for appointment on compassionate ground. And for the year 2020, applying 5% reservation, 22 vacancies were earmarked for appointment on compassionate ground, whereas petitioner's name featured against serial number 34, as a result whereof she could not come within the zone of consideration. Stop. Appointment could not be offered to the petitioner under compassionate ground. Stop. Next paragraph. However, in terms of clause 16 of the said scheme, petitioner was intimated with a letter dated 30th June 2021 on outcome of the decision, intimated on outcome of the exercise made by Board of Officers with a request to apply afresh. Stop. Inadvertently, petitioner could not make application contemporaneously as a result whereof petitioner's application for appointment on compassionate ground, petitioner's subsequent application for appointment on compassionate ground was not on record. Therefore, question of taking decision on such application does not arise. Stop. Next paragraph. While taking delving into the issue involved in this writ petition, this court finds clause 16 of the said scheme provides no time limit for making application for appointment on compassionate ground by the dependent family member. Stop. Therefore, leave is granted to the petitioner to make application afresh seeking appointment on compassionate ground by 3 weeks from date. Stop. If such application is made within the aforesaid time, concerned respondent authority or within the appropriate day, if such application is made within the aforesaid date, concerned Board of Officers shall take decision on the said application of the petitioner in accordance with law within when board of officers when the next board will be conducted. আচ্ছা কি সেন্টেন্সটা বলো। Application in their next meeting, in its next meeting after receipt of such application. Stop. Decision to be communicated to the petitioner by fortnight thereafter. Stop. Next paragraph. Leave is granted to the client advocate representing the petitioner to amend this document and add Board of Officers as additional respondent in course of this day. Stop. However, service of notice upon additional respondent stands dispensed with since answering respondents are represented by learned advocate. Next paragraph. Writ petition stands disposed of virgin xerox certificate. এটা থাকবে কারণ না এরা এদের দুজনেরই নাম দেবে আর কারোর নাম দেবে না তুমি কিন্তু অন্যান্যদের নাম দিয়ে দিচ্ছি আমি কেটে কেটে কারেকশন করেছি আবার তোমার কাছ থেকে এক্সট্রা করে
Item number 23.
My lord, I appeal for the petition.
I am for the NTPC, my lord, led by Mr. Somo Mojumdar. My lord, this brief has been received by today itself, my lord. The instruction not yet been received, my lord. My lord, if he
You are appealing for the petitioner. Who is the answering respondent?
I am for the NTPC, my lord.
Which authority?
The National Thermal Power for NTPC.
NTPC, yes, sir.
You are representing Union of India. Union of India. What is the matter about Mr. Bihani?
And in short, I tell you, Lord. Well, the husband of the petitioner was working in NTPC. Well, subsequently, he was dismissed. He filed a writ petition. That was, my lord, after that, my lord, he was undergoing physical and mental trauma, could not pursue it, was dismissed for default. No, in the meantime, my lord, his he was dismissed, but he also, my lord, even if he was working, his tenure was over. Now, he was occupying a quarter, granted by the NTPC. Now, he wrote a letter to them saying that I want to leave the quarters. The NTPC writes him back a letter saying that this is the amount due, you have taken loan, and this is the penal measure, penal action for overstaying. So you pay that, we will allow you to leave. He writes a letter, my husband writes a letter to the NTPC saying that yes, this was the amount I had taken as loan, but this is my financial and mental condition. It is in accordance with your rules, you are at liberty to waive the penal measures. Kindly do so and allow me to leave. So this went to and fro. Ultimately, the NTPC allowed my husband to leave the quarters. Have an that he left. And he also paid a substantial amount to the NTPC. Somehow eking out the money, he paid the amount. No, that is admitted. Thereafter, he writes them several letters saying that now that I've paid the money, I've left the quarters. Kindly tell me two things. One, what is the total outstanding? What is my return dues now that I am supposed to get from you? Kindly adjust that with your amount, whatever amount you have.
The employee was dismissed from service.
Terminated.
Termination. Then after that, what amount you are entitled?
Well, there are certain.
Accepting provident fund.
That's right. So he wrote to them that whatever is that, he is not he's a layman. So whatever is due, I am entitled to get. Kindly adjust that one thing and give it to me. Secondly, kindly, instead of asking the highest penal rate of interest, kindly keep it at the lowest. This went to and fro. Nothing came out.
Rate of interest on what?
Overstaying in the quarter.
But that you are allowed to leave the vacate the accommodation.
Long after it was due.
Vacate the accommodation,
Yes.
but long after.
Long after. So that was
this period.
Yes.
What was the rent that was calculated along with interest?
That's right.
And penalty
At the penalty and interest at the highest rate. As this was going to and fro, my husband died. The petitioner writes down several representations saying that this is the position, you are aware of that. Whatever is due to me, kindly pay that and adjust it. Nothing has been done. In short, this is the case.
Therefore, you take instruction.
Yes, ma'am.
And produce the calculation.
And I am only on that.
Yes, ma'am.
I am only on that. I am only on that.
Admissible amount should be released, my lord. I kindly give me.
Not admissible. What is to be paid? Admissible will come later.
That is right, I will.
Because the employee died.
Yes.
Now the rent along with interest and penalties was claimed. That has not been paid.
No, some amount
has been paid, some has not yet been paid.
Take a sympathetic.
Well, I'll tell you, Lord. I'll tell you, Lordship. The due was 5.
Removed and the husband died. Would allow the lady to.
My lord, when the husband was alive, my lord, the officer concerned also intimated him. They kindly the reduced pay already been granted.
Yes, but nothing transpired.
Take a sympathetic view.
No, my lord, I'll kindly give me some more time to take instructions, my lord. That will be.
I tell you, Lord, something around rupees 5 lakhs was due. With penal interest, it became 9 lakhs and odd. I have paid 3 lakhs and odd or something. So I was saying my respectful submission right through to them was that whatever can be charged, done, kindly do so and kindly give me, adjust it and do whatever can be. So this is actually in the nature of this, nothing else.
Well, another service, my lord, the cost title should be corrected by the NTPC, my lord. That has been National Thermal Power. NTPC.
NTPC full form.
NTPC.
শুধু NTPC হবে very good করে দে
Petitioner, then National Thermal Power Corporation Limited.
Now, my lord, NTPC.
It has now become NTPC.
From 2000.
NTPC petitioner, NTPC Limited.
Yes, sir.
NTPC Limited.
NTPC করবে সবকটাই NTPC করবে ওই তো NTPC লিমিটেড দাদা এটাই তো এটা শুধু NTPC লিমিটেড সবকটা NTPC
was an employee of
চেঞ্জ হয়ে গেছে
NTPC Limited who was removed from service on initiation of disciplinary proceeding.
My lord, that should be not.
No, terminated from service because of his unauthorized absence.
Must be. The husband of the petitioner was terminated from service.
Well, I don't think there was disciplinary proceeding.
Terminated from service. And thereafter, he died.
That's right.
So, why being the petitioner is claiming terminal benefits, adjusting the amount which is required to be paid for staying at the accommodation provided by NTPC. Mr. Bihani, learned senior advocate representing the petitioner, has said that already part payment has been made by the petitioner or the husband.
Husband of the petitioner.
By the husband of the petitioner towards charges levied for occupying quarter of NTPC. The learned advocate representing NTPC Limited has prayed for accommodation to obtain instruction. Concerned authority of NTPC Limited is directed to submit a calculation sheet disclosing the amount which is to be paid to the petitioner on necessary adjustments. Stop. In view of death of the husband of the petitioner, this court expects that NTPC Limited shall take a sympathetic stand. Stop. Let such calculation, let a statement of calculation be produced by 10 days from date. Hearing of this matter.
Some more time because the new officer has been joined, my lord. That is the difficulties.
By fortnight from date. Hearing of this matter stands adjourned till 17th or 17th December 20.
MD close.
Yes, is there any necessity to correct the cost title?
And that is required.
Next paragraph, leave is granted to the learned advocate representing the petitioner to amend the cost title and describe NTPC Limited appropriately. Stop. Let such amendment of cost title be made in course of this.
Not only one thing, well, this will on the returnable date, this will appear as the motion.
No, it is from the combined list. So till 17th, matter will not be called on. Thereafter, it will be called.
Deeply over.
You take help of other side.
Yes.
So you both of you come here and make the amendment. Next.
Item number 24.
Time for the High Court administration.
Time for the state.
24, I am having for the teacher.
But I am for the district judge, my lord.
Who is for the High Court? And state, you are appearing for the state.
যথারীতি লেখা হবে কেন এই পেনগুলো ইউজ করি
Yes.
Well, here the petitioner, well, I am challenging first, well, that is page 45. Page 45, I am challenging by filing of this writ application, which has been passed by the joint secretary well, on 12/11/2024. That is, my lord, second para, the administrative department.
Just a minute.
দেখে নিচ্ছি পশ্চিম বর্ধমান
Yes.
My lord, MCAS I did not prayed before the district judge.
Career advancement scheme.
That was not prayed.
What is aim?
My lord, aim that is modified
career
advancement scheme. That was not prayed by the petitioner. My lord, actual case is the petitioner joined in the year 2014 at the my lord as a LDC in the under the judgeship of Shialda. After that, the petitioner transferred from Shialda to Kakdip, that is South Chobbish Pargona. Then, my lord, on the strength of inter-district transfer, the petitioner prayed for transferring him from Kakdip to Paschim Bardhaman, and that was
because Paschim Bardhaman is his hometown.
Yes, and that prayer made before the Registrar General, and after considering of all the things by way of mutual transfer, the petitioners transferred from Kakdip to Paschim Bardhaman, and one incumbent
on 13th August 2024.
Yes. My lord, after that, on 13th August 2024, the petitioner joined at the Paschim Mendripur, Paschim Bardhaman, and the petitioner got the scale of pay of level 9, that is at the UDC scale. Subsequently, the petitioner promoted from LDC to UDC, and the petitioner, after joining 4 months, petitioner got scale pay of UDC, and subsequently, on all a sudden, the district judge declared him as a LDC, and gradation has been fixed at the entry level, and his pay salary has been deducted from
when the petitioner was downgraded from UDC to LDC.
UDC to LDC, that is on 21st August 2024, that is 42A, page number 42A. And after that, we subsequently, when joined as in the under the judgeship of Paschim Bardhaman, immediately the petitioner made representation before the authority, because the incumbent who by way of mutual transfer joined at Kakdip, he got UDC scale, and petitioner got LDC.
The case of mutual
transfer. The incumbent who joined from Paschim Bardhaman to Kakdip, he got UDC scale of pay.
Party.
That I not. And the petitioner subsequently deducted from UDC to LDC, and bottom of the list, and the initial stage of service, the petitioner allotted the pay scale, that is page 42A, by the district judge in charge accounts Asansol. The petitioner did not pay any MCAS. Petitioners actual grievances from level 9 to level 6. If your lordship can see page 27 by joining.
Now, one judgment is
What is judgment by the Supreme Court?
No, in the order in support of the decision of the Joint Secretary Finance Department or Joint Secretary to the Government of West Bengal Judicial Department. It is stated that Judicial Department took decision based on observation made by the Finance Department. Now, Finance Department observation is within the quotation, page 45, where it's stated that subordinate courts in terms of geo number so and so dated with order dated so and so passed by the Honorable High Court in connection with 7241 of 2024
Yes.
Firoz Alam.
Yes.
Where is the judgment?
Annexed. I annexed, and that was subsequently my lord, modified by the division bench. I annexed.
Where
the
is that order of Firoz Alam?
Firoz Alam, that is page, my lord, 46.
46.
And division bench order page 49 onwards. Where is the order of the Honorable Division Bench? My lord, that is page
49.
49 onwards. On a relevant portion, para 16, page 53 onwards.
But you are not granted the benefit. Yes, order of the coordinate bench was modified to the extent of your entitlement to get benefit, or to the extent of appellant's entitlement to get benefit while he was in district judgeship Bankura.
That is separate
But
issue.
if it is a case of transfer on your own volition, voluntary transfer, then you will be placed at the bottom of the gradation list.
Yes,
in
my-
in the transfer post under the new judgeship.
Yes, that was, my lord, that will affect my seniority.
Yes.
That will, here, my lord, from UDC to LDC.
Yes.
My
At
lord,
the
that
bottom of the
UDC, bottom of the UDC. My lord, I will be bottom of the UDC.
Come to paragraph 19 of the judgment of the Honorable Division Bench.
Yes.
Read it. The scheme
The
of
scheme transfer which allows a transfer at the initiative of the appellant does not specify that the appellant will not receive benefits which accrues to him in his past service, so long he was there in the previous judgeship. It prevents the concerned employee from carrying forward the benefits of his
prevents the
service.
concerned employee from carrying forward
the benefit of the service.
at the past,
judge-
benefit of his service at the past judgeship, but does not disentitle him to receive the benefits accruing to him at the previous judgeship till he is there in such judgeship.
My lord, here.
Now read it. In other words.
In other words, if any monetary benefit accrue to the employee concerned in the previous judgeship for the period of time that he was there in such judgeship, and such monetary benefit is declared subsequent to his transfer, such employee would be entitled to the monetary benefit for the period of time that he was there in the previous judgeship. He may not be allowed to carry forward such benefit to the new judgeship, but since the benefit accrued to that employee for the work done in the previous judgeship, the same cannot be denied to him for the period during which he was in the previous judgeship on the plea of the scheme of transfer. My lord,
So everything is confined to your service in the previous judgeship, or everything is confined to the service of the incumbent in the previous judgeship.
My lord, here,
How does it help you?
My lord, here issue is different. Here, my lord, I claimed before the single judge that my past benefit was not given. My lord, they joined me as a LDC. I allowed. I did not raise my voice. Here, my lord, after, my lord, they joining me as a LDC, my lord, raised my voice.
No, is it a case which has been made out in this writ petition claiming your past benefits in connection with your
here that is
with
not.
your service under district judgeship South 24 Parganas?
No, this is
Then-
not my case.
Then how
This
it
is not my
then
case.
where is the wrong in the decision?
My lord,
taken by
if
the
your lordship kindly see for a moment the joining.
Let us come back. Let us come back to the order, page 45.
My lord, once upon a time, my lord, my release, my joining, my lord, page 40.
Where is that scheme of transfer?
My lord. This is the scheme.
Everything is with her.
My lord, this was, my lord,
All
my,
the matters
no, my lord, this was my mistake, my lord, my lord.
All the matters in the service I found, while under friend is appearing for petition.
Kindly see for a moment page 40, my joining, and my lord, in my mutual transfer, one incumbent joining. My lord,
Inter-district transfer scheme, just a
Yes.
minute, just a minute.
page 40, page 38. Well, this was my mistake, my lord. That was not an
My lord, one thing, my lord, my learned senior friend
Just
is
a minute, just a minute.
Clause 5, my lord. Is the
Yes,
relevant.
yes.
Yes.
That is,
Six
I am
will
on
be
clause
applicable.
5. Just a
Clause
minute,
five
just a
is
minute.
not applicable. Clause 6 applicable.
It is no. I have seen the order passed by the coordinate bench where clause 5 and 6 were considered. However, when the transfer is made at the initiative of the applicant concerned, he will not get any benefit of his past service, either permanent or temporary in the parent judgeship. In other words, his name will be at the bottom of the gradation list of both permanent and temporary employees in the district where he is transferred.
My lord, this was, my lord, yeah, my lord, kindly see for a moment page 38. Page 38. My release order and my lord, the mutual transfer, the one incumbent release order.
No, I will not enter into this issue that another person who was on transfer on mutual basis is getting what benefit.
My lord,
If it is wrongly that benefit is given to him, that will not confer right
my
so
lord,
far you are
this
concerned.
was, my lord, only affect my seniority. My lord, nothing more or nothing
But
less.
can you are
My
bound,
lord,
you are bound by this group clause 5 of the transfer
yes,
scheme of
my lord,
25.
that will affect the only seniority.
Issue.
Only seniority. My lord, I have, my lord, several Supreme Court judgment, my lord, that is
Issue is decided by the division bench. I am not taking any different views over division bench.
My lord, I was UDC. Now I am LDC.
That is the part of the scheme.
My lord, I will be, as my
Yes.
I will be UDC bottom. I will be UDC bottom.
That is the scheme. What it says.
My lord,
It says, however, when the transfer is made at the
Yes.
initiative of the applicant concerned, he will not get any benefit of his past service, either
Yes.
permanent,
Yes.
either permanent. He will not get any benefit of his past service, either permanent or temporary, in the
Yes.
in the parent judgeship.
Yes.
In other words, his name will be at the bottom of the gradation list of both the permanent and temporary employees of the district where his
My lord,
bottom of the gradation list.
they joined me as a LDC. And LDC pay scale has been allowed after giving 5 months UDC pay scale. My lord, now their initiation of the service, the pay scale has been, my lord, declared.
You are in the UDC pay scale.
UDC.
Yes.
I was UDC. I mutual transfer with UDC incumbent. My lord, now I joined UDC. After 5 months, they declared me as a LDC, bottom of the list.
Yes,
And at the initial,
that is the part of clause 5.
my lord, I will be UDC bottom.
But on the basis of, on the strength of the judgment of the Honorable Division Bench, your claim as UDC in connection with your service in previous judgeship will not be impacted.
My lord,
you will get the benefit of UDC.
Yes.
In respect of your service as clerk, which you have rendered under the judgeship of South 24 Parganas.
Yes.
But on the date of your transfer to the judgeship of Paschim Bardhaman, that right goes.
My lord, I will be,
and that has been held by the division bench also, because it is a case that when with a retrospective effect promotion was given from LDC to UDC.
Yes.
And the Honorable Division Bench has held, yes, so far the service of the petitioner in respect of district judgeship of Bankura, he is entitled to get all benefits till the last date of his service in district judgeship Bankura. But after transfer, his right evaporates.
my lord, now I am the initial pay scale of LDC. I will be UDC bottom of the list. I will be UDC bottom of the list. My lord, same designation will be covered. My lord, but now they declared me as a LDC. If your lordship kindly see for a moment page 40, I will be UDC bottom. My lord, that is no problem. But they treated me as a LDC bottom. All temporary and permanent staff bottom of the list. They treated me as a LDC.
See, it will be considered as a fresh appointment.
But that was not.
That is the part of clause 5. Come again to
Yes,
clause
yes,
5.
yes. My lord, I am.
It says, however, when the transfer is made at the initiative of the applicant concerned, when the transfer is on the own volition of the applicant,
Yes.
because he will not get any benefit of his past service.
Past judgeship.
He will not get any benefit of his past service, but not past judgeship, past service, either permanent or temporary in the parent judgeship.
Yes.
That means in the previous judgeship. In other words, his name will be at the bottom of the gradation
It is a
list
list
of not on the same cadre.
My lord, that is.
No, what is the part of the of this clause second part of clause 5? He will not get any benefit of his past service.
Yes.
Past service means you will be treated as a new entrant in the district judgeship of Paschim Bardhaman.
My lord, these This was
It will
only,
it will be completely a new, fresh appointment.
my lord, all,
Had it been provided here under clause 5 that in other words his name will be at the bottom of the gradation list in the same cadre, then your prayer could have been accepted.
my lord, this will
But
all,
when it is said that, however, when the transfer is made at the initiative of the applicant concerned, he will not get any benefit of his past service. Your past service evaporates.
my lord, that is only affect my seniority. My lord, as per Supreme Court judgment, my lord, that is only, my lord, affect my seniority. My lord, I am in, my lord, LDC.
My lord, the case of the petitioner is covered by the clause 5 and 6, most only 6. And to that effect, my lord, if you kindly come to page 36.
6. I am
Yes.
considering 5.
My lord, 6, my lord, he is a mutual transfer in a mutual basis.
আচ্ছা একটু বসো তো ও মিউচুয়াল ট্রান্সফারটা একটু দেখে নিই ইন কেস অফ ইন্টার ডিস্ট্রিক্ট ট্রান্সফার
In addition, my
জাস্ট এ মিনিট
5 and 6 both consider করে দিন। এসসি এসটি দিয়েও 6 লাগে, এসসি এসটি তেও বেশি
Yes. Now what is your submission?
My lord, page 36.
36 of the writ petition.
Writ petition. Page 35 is his application before the district judge. Page 36, my lord, third paragraph.
It says that I belong to SC category and I also declare that I will forego my promotion in future in reserved category in my service if my service is transferred from Jatship of so and so to Jatship of Paschim Bardhaman. I shall not claim any promotional benefit from my past service in the parent Jatship and I have no objection if my name will be at the bottom of the gradation list of UDC.
My lord, UDC, my lord, obviously he will be considered as the UDC. My lord, kindly turn to next page.
UDC of the district where by where he seek to be transferred. So he has said that yes, I will not claim for any. I shall not claim any promotional benefit from my past service, and I have no objection if my name will be at the bottom of the gradation list of UDC.
My lord, kindly turn to next page. My lord, transfer order of High Court.
Next page.
Next page, page 37. My lord, both are.
Just a minute. Usual terms and conditions.
That means, my lord, both of them will be considered as a, my lord, upper division clerk at the time of applying. But when they are transferred, my lord is rightly observed, my lord, clause 6 cannot run independently. Clause 6 will be run with the clause 5. Automatically, upper division clerk will
Then
be
how
run.
the person who has been transferred from Bardhaman, Paschim Bardhaman to South 24 Parganas is placed at the gradation list under UDC?
Well, that is a wrong. That cannot be. Under the rules, that cannot be.
Think about a situation. Admittedly, petitioner was UDC under district judgeship South 24 Parganas, and the person Dipen Das was also UDC under district judgeship Paschim Bardhaman. This is a mutual transfer. Now, on mutual transfer, petitioner has been placed at the bottom of gradation list as LDC, whereas Dipen Das has been placed at the bottom is being treated as UDC.
Well, that should not.
How that can be considered?
That cannot be. He should also be considered as an LDC. That's the scheme of the High Court, and that
But
has
he
been
has prayed for gradation list of UDC. Petitioner has said in his undertaking by affidavit as contemplated under clause 6. It says that may submit under clause 6 of the scheme may submit an affidavit declaring that after joining the new station of posting, she will render his office duties foregoing his seniority
And also
would
foregoing the
forego the
promotions.
promotion in future to reserved category.
Promotions.
And this provision will ensure that no candidates belong that in the
Also
case of
promotion.
mutual fund where one candidate belongs to general category and to reserves, then applicant who belongs to silk category may submit an affidavit declaring that after joining new station of posting, she will render his office duties, foregoing his seniority and would forego promotion
In future.
foregoing his seniority and would forego in future in reserved category. So if this is the situation, then clause 5 will not come into play. This clause 6 will be considered because it is an exact case where it's a mutual transfer between a general category candidate and the scheduled caste category. It's a scheduled tribe to do.
Scheduled tribe.
So the reserved category candidate. Now, after mutual transfer, why the candidate or the incumbent who is now working under district judgeship South 24 Parganas will be treated as UDC?
Well, that should not be. My lord,
Who is
the
applying for the
language,
state?
a language used that, my lord, in addition.
How he will be considered as UDC?
My lord,
At the yes, in terms of the scheme, what has been done, it has been rightly done. But another candidate will be termed as will be considered as UDC. Why?
my lord, on that score, I have to take instructions, my lord. But may I submit one thing with regard to page 36? He has given an undertaking against his right.
No, that undertaking page 36 is conditional. It says that a promotional benefits from my past service in parent judgeship, and I have no objection if my name will be at the bottom of the gradation
Of
list
UDC,
of UDC.
of UDC.
Now, but he has been placed as LDC. Whereas the candidate or incumbent who has been transferred from Paschim Bardhaman to South 24 Parganas,
he is under
treated as
UDC.
UDC.
He is under UDC, my lord.
Why?
But, my lord, we have to take instructions on that score, my lord. But so far as, my lord, this undertaking is concerned, undertaking against a right cannot be an undertaking. This is my respectful submission. He has stated, I belong to
No,
schedule.
no, court is considering the scheme. In one hand, he will be placed at the bottom of the LDC cadre,
And another,
whereas another will be
under the
considered as a UDC.
UDC
How
cadre.
will
Why
be countenanced?
my lord, on that score, I have to take instructions, my lord.
You make Dipen Das as party.
Yes,
Party serve notice, obtain instruction.
lordship.
Because you have rightly pointed out, it is not a case under, I was about to pass an order considering clause 5, but it is not a case under clause 5, it is a case under clause 6, it's a mutual transfer. So if it is a case of mutual transfer, then it says that will render his office duties foregoing his seniority and would forego promotion in future in reserved category.
Both should be equal.
Already in
And
future.
would forego promotion in future in reserved category.
Seniority
So
only.
therefore, both are required to be placed as
Same
LDC.
Same cat, LDC.
Why petitioners will be
That's
will
why,
be
my lord, I
penalized
pointed
and
out.
another
Same
candidate
problem
who is
cropped up
similarly
in other matters.
circumstanced will work as a UDC?
The same problem cropped up
And
in
my lord,
another matter.
after joining 3 months, he is working as a UDC. Then
That can be corrected, but it is not a case. You have to forego your seniority. You are required to be treated as a new entrant in the service. That will not ameliorate your case.
He will
Only
be
another candidate needs to be considered as a UDC, LDC, not UDC.
LDC.
But before doing this, I need to hear the said party. If today I pass an order that both should be placed as LDC at the bottom of the gradation list, then cause injustice to the that candidate.
Dipen Das.
Leave to appeal. Remand.
Yes. Interesting.
My lord, Dipen Das address was not, my lord, available. My lord, only.
State will provide it.
Yes.
State will provide it and the High Court will provide it.
Now working and my lord, South
Easy.
24 Pargana.
district judge will be asked to provide by the High Court. I will direct the High Court to provide the address because he has taken the right submission. First of all, it is not a case under clause 5. It is a case under clause 6. And not only this, that the both are to be placed at the bottom of the gradation list.
তুমি বেনিফিট পাবে না ও নিচে চলে আসবে তাই হবে চলো
ডিস্ট্রিক্ট জাজের হয়তো তুমি অ্যাপিয়ার করছো
না সাউথার্ন নয় আমার অ্যাপয়েন্টমেন্ট শুধু বর্ধমান
Matter is heard at the presence of the learned advocates representing the petitioner, district judgeship Paschim Bardhaman, High Court administration and state respondents. Question arises for consideration in reference to communication dated 12 November 2024 made by the Joint Secretary to the Government of West Bengal Judicial Department. Whether after mutual transfer, petitioner to be placed at the bottom of the gradation list as UDC or LDC. Stop. It is submitted by the learned advocate representing the petitioner that after mutual transfer, one Sri Dipen Das who was working as UDC in UDC under district judgeship Paschim Bardhaman is being treated as UDC under district judgeship South 24 Parganas, but petitioner is being treated as LDC under district judgeship Paschim Bardhaman. Stop. Next paragraph. At first blush, on perusal of clause Roman 6 of the circular dated 19 June 2012 or এরকম ভাবে করো না কি সেন্টেন্সটা বলছিলাম না on perusal of the scheme for facilitating inter-district transfer issued by the Registrar General High Court at Calcutta dated 19 June 2012. Both the candidates or both the incumbents are required to be treated as LDC, not UDC. Stop. Next one. However, said Dipen Das has not been arrayed as respondent in this petition. Stop. Next paragraph. Learned advocate representing High Court administration is directed to share details, share address of said Dipen Das, address and other necessary particulars of said Dipen Das with the learned advocate representing the petitioner by 7 days from date. Stop. After receiving particulars of said Dipen Das, leave is granted to the learned advocate for the petitioner to amend the cause title of this writ petition and add said Dipen Das as additional respondent within 2 days thereafter. Stop. Learned advocate for the petitioner is directed to serve notice upon additional respondent, enclose amended copy of the writ petition and the order passed today by 10 days thereafter and file affidavit of service on the next date. তাহলে 7 days, 2 days, 10 days, তাই তো হলো? This the matter under the same heading in the monthly combined list of January 2025.
Lakshmi, kindly add one line.
Affidavit of service today you have filed.
Yes, yes.
Affidavit of service filed on behalf of the petitioner is taken on record.
Lakshmi, kindly add one line, my lord. Kindly direct the respondent number 2 to file a report.
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 Why at this stage? You give your appearances.
Grateful, ma'am.
Item number 25.
সেন্ট্রাল গভর্নমেন্ট রিপোর্ট দেবে না আমার উপর তো রেস্ট প্রথম অর্ডারেই বলা হচ্ছে প্রথম অর্ডারেই বলা হচ্ছে 4 and 6 4 and 6 আমি হচ্ছে কি 1 to 5 না 4 আছে 1 to 5 মানে তো 4 and 6 Any. Four and 6. 4 hours.
Report.
I have not received any instruction. Some more time.
Yes.
Some more time may be granted.
But last occasion time was granted on 11 November
Call number
2025.
6 and 7. I have drafted my report, my lord. It has forwarded for legal vetting, my lord. It has not yet come.
6 and 7.
6 and 7. I am
Oh, you are
report-
representing Union of India.
Union of
6 and 7 were directed to
4
file.
and 6. 4 and
7.
Last.
Actually,
you are representing 1 to 5.
1 to 5.
6
So-
and 7.
6 and 7 FCI. But 1 to 5 is the Union of India. Union of India was also required to file a report.
Union of India is the main party, my lord. We are just following the direction of the Union of India.
As per the first order, respondent number 4 and 6. 4 and
First order, no? No, it is
One-
a last order.
First order to we are not appearing at that time, no? No, appear first. বোধ হয় একটু ফাস্ট করতে বের কর না মোবাইলে বের কর মোবাইলে বের কর তাহলে 4 and 6 1 to 5 includes Union of
No,
India.
by order dated 8 May 2025 passed by the coordinate bench. Respondent number 4 and 6 shall
Right.
file if
Therefore, Union of India as well as FCI.
directed to file, but 6 is FCI.
Yes.
Chief General Manager.
Yes.
Transitory closure same. Yes. Both were directed.
4 and 6.
Yes. What about the report? His report, when you will, nobody has filed report.
No, I know, I have drafted.
One has filed report.
No one.
I have drafted, I have forwarded the legal.
This is an order dated 8 May 2025.
I
How
thought-
long
I thought
it
that was-
takes to reach Delhi and come back nowadays?
Problem is this.
It is an era of information technology.
I have drafted.
By one day it can be done.
Vetting, legal vetting is required.
They will pay cost of rupees 50,000 for causing delay.
But the government actually sent us the instructions. We shall, otherwise,
Say that he will not file any report. Court know how to deal with it.
Here the report.
No, not at all. I will compel the authority to file a report, directing the authority to appear before me personally.
I have drafted.
Sorry, Mr. Chattopadhyay. Don't be too clever before this court.
Well, I am not. I'm just making my prayer. Well, I give me some time. I shall file.
Some time means this order was passed on 8 May 2025.
I was waiting for the government's instruction. Well, we are just following their instruction. We are not getting the instruction. That's why I have prepared my report. But I was just waiting for their instruction. my lord.
If the no instruction
No, I
comes,
have, that's why I have prepared my report on my own way and I have sent it to my filed it. So I shall file it. So that they will give your note, I shall file it.
Apology, my lord. They have not as yet, I have not as yet received instruction. My lord. I will immediately.
have you sought for instruction?
I have.
Show me how you have sought for instruction. Show me. Yes, please show me how you have sought for instruction. Let me see. I know all these things. Show me.
I don't have it.
How you have sought for instruction, please show me. When you have sought for instruction. These are these things are very much known to us. Yes, show me how you have sought for instruction. It's very easy to say everything before this court. Show me. That by this letter or by this email or by this you have sought for instruction. Show me. When you have sought for instruction, tell me. Yes, yes. Your contention is this, that you have sought for instruction, but it was not provided to you. How you have sought for instruction? That letter should be with your brief. Where is such letter? If it is by email, that copy of the email will be with your brief. Where is that instruction? Now the name of another advocate is coming in.
My senior, Mr. Ashok, because he was actually conducting this. He has fallen ill for a long time. So that is the reason why he would have decided to have. After he was.
Let me appoint Deputy Solicitor General in this matter.
But better, if my learned friend seeks 1 week time, that may be granted, subject to your lordship's kind consideration.
He is not in a position that where is the compliance so far advocate is concerned. You will intimate it to the department for instruction. Otherwise, how it is possible?
2 weeks time, I will complain.
How long this will continue? Tell me. 11 November 2025 order. Prior to that, it was on 8 May 2025.
Let there be peremptory order, my lord, in that case.
What is the matter about, Mr. Rai?
But this is one unit of the Union of India, which was running from Sector 5 Salt Lake. That was closed down. The
unit of FCI,
not nutrition, food and nutrition. FNB. Food and Nutrition Board.
Public Nutrition Department.
Yes. That was closed down. The staff of that unit were required to be sent to the no, staff of that unit were required to be sent to surplus cell for being appointed to any other unit. Now the thing is this, they were directly sent to Food Corporation of India, all of them. That is the whole. That is in violation of the guidelines in respect of closure of unit. How the staff would be conducted, the manner in which the staff would be posted.
Now the petitioners are working in
FCI. But we do not have any choice.
What do you want? You want repatriation from FCI to other departments?
To surplus cell, so that we can be properly transferred to some other department. Because why FCI? And not the voluntary retirement scheme.
From which date you are working in FCI?
2023, the deputation was issued. Deputation, they were sent on deputation to FCI. They are working on deputation, not actual transfer. 2023, they are working. But all of not in FCI East Zone. But only East Zone there are 10%. All India is not connected with the Calcutta High Court jurisdiction. They are not come.
But that I shall deal. In paragraph 2, I have.
Why it is not within the territorial jurisdiction?
They have been posted on other zone, other parts of India.
Where in FCI?
In FCI.
But they are working in
Yes. Not in East Zone. East Zone.
no, while they were in the nutrition
Board.
unit,
Yes.
then they were working in sector 5.
Yes.
Government, they are not connected with us. They just, as per cabinet's decision, they just posted on. They are just thrust on us as a deputation.
No, deputation. What is who is the parent organization?
The Ministry, Nutrition Board. There is a government of India.
But they are working in sector 5.
That was the office of the nutrition board. That was the office of the nutrition board.
That was abolished.
Lord, that was closed down. Thereafter, you were required to be posted to surplus cell, from where we could have been posted. And Lord, we have been deprived of not choosing VRS, opting for VRS.
You don't want to work.
No, because Lord, some benefits have been curtailed. But since we have been sent to FCI, some benefits, service benefits have been curtailed.
Page 92.
92. Office order, implementation of the cabinet decision on transfer of employees from the they are bound to accept them as per government instruction.
Guidelines to be no, it's a violation to this. It's a violation.
I have stated all in my report, I have drafted already. So we can see the terms. There, clause A, deputation, not in transfer. But we have joined a
So this is under challenge.
This is under challenge. Well, these are 23 challenges, 25. After 2 years, and not only transfer, this is deputation. The government can anytime take them back. We have nothing to do with it. They're just following the government's decision. And if the report will not take it as such.
So, Rai, on what basis you are challenging this?
Because Lord, there has been violation of the guidelines of the central government. Lord, regarding Lord, surplus staff, Lord, kindly see page 76 once. Lord.
But that it is said that this cabinet decision on AMAS transfers of employees of Food and Nutrition Board on deputation Food Corporation of India.
Lord, this cannot be done this way, Lord. Kindly see page 76.
This is group A.
76. Can I produce? But this is the Ministry of Personnel, Public Grievance and Pension, Department of Personnel and Training.
আমার 76 আলাদা ওর কই কি দেখছি আমাদের 76 আলাদা
দেখি পরের পাতাটা যান পরের পাতাটা
না না পরের
ফিক্স করে দিয়েছে
ও এটাও 76
Now Food and Nutrition Board FNB, there you are saying that there was an unit of FNB here at Kolkata.
Yes, ma'am.
Now that unit has been abolished.
Yes, abolished.
Now there is a cabinet decision for mass transfer of the employees working in the unit under FNB,
Right.
and they are it is a case of deemed deputation to FCI. Now this decision was taken by the cabinet, and they are transferred to different offices of FCI which are not within the territorial jurisdiction. Decision to transfer was made by the cabinet. So where is the territorial jurisdiction to consider this? Because that unit is no more alive here.
No, why? If your lordship kindly see paragraph 2 of the writ petition regarding jurisdiction, I have stated, and paragraph 2. Paragraph 2 at page 10, that your petitioner state that one of the regional office under the Ministry of Women and Child Development Department, being the Regional Food Testing Laboratory, Food and Nutrition Board, Ministry of Women and Child Development Series, Sirish Bagan, plot number so and so, premises number, action area 3, Newtown, near 19 Water Tank, Kolkata 7,160,000, was in the state of West Bengal prior to closing of the same, and as such the part of cause of action arose within the jurisdiction of this honorable court. After closure of the Kolkata office, the petitioners are being sent to different offices of Food Corporation of India situated at various locations all over India. Some of the petitioners are now being posted at different places of FCI without complying with the rules regarding redeployment from surplus sale. Since the
how your territorial jurisdiction is attracted?
Because we want to go back to the surplus sale, because if your lordship sees page 76,
but this decision is taken by the cabinet at Delhi.
That is in,
and it's a case of deemed deputation to other lending organization, that is FCI.
That cannot be done.
And none of the petitioners are working in state of West Bengal.
No.
10 are working.
10 are working.
Therefore,
And
what
then part of cause of action is there.
Part of cause of action is there.
That, Article 28, 226(2).
Yes.
With regard to others, but the decision was there in Delhi.
The petitioners at least 10. I am thinking that all of the petitioners are working outside the state. That is not the issue.
I've given the number, but I'm giving the number.
No, let them file report. We shall deal with the report by filing exception.
6, 7, 8, 9.
But still, you are working in FCI now.
What
this report will do?
No, this is
matter needs full-fledged hearing.
That's correct. That's correct. But thing is this.
No, file your affidavit.
Yes. Yes.
I said file a report.
It will not appear under the heading motion. It's a full-fledged hearing is required.
I have taken a point in the report because I have
you file, since you have not affirmed it, you file an affidavit.
Yes.
I will grant you time.
Well, let it be taken for hearing as a motion.
Before also kindly goes to paragraph
The writ petition matter is heard in presence of the learned advocates representing the petitioners, Union of India and Food Corporation of India. Stop. Learned advocates representing Union of India has prayed for accommodation to file a report. Stop. Learned advocate representing FCI has submitted that some more time is required to file the report. Stop. Court has considered the merit. Court has considered the issue involved in this writ petition, and it appears that vide office order dated 28 December 2023, petitioners were এনমাস, আমাস, ডেপুটেড
কেউ কি গ্রুপের কেউ নেই সবাই কি গ্রুপ
FCI
ডিএসপি সবাই
and working in several establishments of FCI.
NICCT
Also
তে
submitted
group
that
H-
at least 10 petitioners out of 24 petitioners. Out of
more than there are
No, 34.
34.
Blood, out of
34 out of 34 petition কি বললাম it is
11 are in West.
out of 11
11 are in East.
it is submitted that at least a দরকার নেই. It is submitted that 11 petitioners out of 34 are working on deputation in FCI in state of West Bengal.
East Zone, East
Stop.
No, not state of West Bengal, East Zone surrounded in Bihar, Odisha also. Specifically,
How many are working in the state of West Bengal?
that I have to specify in the affidavit. Well,
আচ্ছা কি বল
তাহলে some sir
সাবমিশন করে দেবেন
come here, but there are 52 details further.
না it is also submitted বাকিটা কেটে দাও. It is also submitted that some of the petitioners are working on deputation in FCI in state of West Bengal. However, number of such petitioners today is not disclosed. Stop. Next paragraph. Taking note of the deemed deputation order dated 28 December 2023. Court finds there is no scope for passing any interim order at this stage. Stop. Issue needs to be decided on exchange of affidavits. Let affidavit in opposition to this writ petition be filed by 1 week after ensuing Christmas vacation. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Next paragraph. Petitioner parties shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavit.
One thing, yes, one petitioner has filed a way.
No,
Next
just a minute.
matter,
Let
please.
me-
Enough is enough.
Blood, only one thing, blood. Just a minute. আমি বলছি আমাকে বলতে দাও blood petitioner number 10 be deleted because he has confusion because he has possibly approached the CAT Central Administrative Tribunal. So blood, let his name be deleted. We have received instruction to that effect.
আচ্ছা একটা লাইন add করে দাও. The learned advocate representing the petitioner submits that name of petitioner number 10 be expunged. Name of petitioner number 10 is expunged from array of petitioners in the post title of the writ petition. Since petitioner has approached a different forum.
Yes.
So, leave is granted to the learned advocate for the petitioners to amend the post title expunging name of petitioner number 10 from expunging name of petitioner number 10 in course of this.
Can be time for filing the affidavit.
Next matter.
2 weeks. One more.
Next matter, please.
Item number 26.
Let me issue that. But after the petition.
Here I'm here. This Corporation of India.
My lord, this matter, my lord, pertains to, my lord, the wage revision of the petitioner and, my lord, the action of the respondent LIC in recovering, my lord, from the salary of the petitioner. So, my lord, what happens here, my lord, there has been, my lord, wage revision of the LIC, which has been, my lord, time to time it has taken place. Yes. So when it has taken place time to time, 2021, 2024. So my lord, that wage revision, my lord, said that pursuant to this notification of the central government, the wage of the LIC will be increasing from X to Y. And 2024 said it will be increased from Y to Z. So this way. So my lord, nowhere in that particular notification of the central government, it says that the clause, the disabling clause of someone from getting this benefit. So my lord, the LIC.
Where in the notification is provided?
Any disabling clause, or my lord, it provides some clauses which says that
these are the situations in which the benefit of wage division will not be given. X, Y, Z, this benefit of wage division will not be given. However, so my lord, there was my lord instruction my lord, that has been issued by the general manager of the LIC, my lord, which says in a particular clause of that particular instruction, it said 20 plus 20, it said that whoever approached the courts will not be getting the benefit of this wage divisions. That particular clause, my lord, we challenged in this other writ petition and this writ petition as well. So, my lord, my specific contention before
What is the fate of other writ petition?
my lord, in other writ petition, my lord, interim order was, my lord, granted by the honorable court, by the honorable single benches, where, my lord, it had been specifically stated that this particular clause is completely arbitrary, since the parent notification does not provide any such embargo. So they cannot employ this right now. Now, my lord, apart from this, my lord, they have challenged that order of the honorable single bench before the honorable division bench. The honorable division bench affirmed the order of the honorable single bench. This is not end here. After that, my lord, they have themselves issued notification by saying, no, from now on, everybody will be given with this benefit. But even in spite of that, my lord, my recovery is being.
Where is that notification that everyone will get it?
My lord, if the notification, parent notification.
No, the notification that
I challenged.
New notification whereby all were decided to be beneficiary to this
Yes.
division.
My lord, 119, if I can take your lordship. 8 or 9. My lord, the last notification lordship asked. Yes, I'm sorry.
Yes, you are saying
119.
you have submitted that 119.
Yes. Fourth of April 2024.
Now, any proceeding was initiated against the petition. Now, the
But
question is that the pay scale or pay of the development officers against whom proceeding was initiated. Now,
That is only question before you.
that was the only question.
So, my lord,
What is the present stage of the proceeding?
my lord, this is one of the proceeding lordship has dealt with, the show cause proceedings.
But that is in connection with 2016 amendment rules.
Well, so in one of those matters, this petitioner also obtained the order of stay from this honorable court earlier round of litigation. Well, if I request your lordship to the impugn notification once, which is at page number, well, I tell you lordship, 39.
This has nothing to do with 2016 amendment rules.
Not at all. But page number 39.
Now, you are harping on this that in view of the above, you are requested to note that the development officers were like or equal with the other development officers against whom no proceeding is.
Absolutely.
So they are
That is
treated equally.
Absolutely.
During the procedure.
Absolutely. This is why only prayer before your lordship. Now, my lord, I'm sorry. Should I come back, my lord, tomorrow?
Then you will come back.
Grateful.
I will give my reply.
Yes.
I will give my reply tomorrow. my lord.
I'll submit, my lord. I'll be taking 2-3 minutes more of your lordship.